All right, good afternoon, everyone. This is the special magistrate hearing for both variances and code enforcement issues. The first set of public hearings we're going to have today are on the variance issues, and then we're going to take a short break and we'll begin in code enforcement. So if you're here for the code enforcement, you are in the right place. However, you're down on the agenda, and that's going to occur immediately after we go through all of the variances. So with that, welcome to the City of Madeira Beach Variance and Special Exception Use Special Magistrate Hearing. My name is Bart Valdez, and I am the appointed Special Magistrate to hear today's cases. I'm a practicing attorney and have been a member of the Florida Bar for over 20 years. I've been appointed to this position in accordance and with the authority set forth under Florida law and the City of Madeira Beach Code of Ordinances. It is my role to fairly and objectively review the matters presented today in these variance requests. As such, I would like to advise you of certain matters related to today's proceedings. Today's matters will be heard in the order that they appear on the agenda. At this time, I have read and reviewed the applications with all attachments, any written submissions by anyone having an interest, any timely submitted written objections, and the materials provided by the city staff. In all cases, the hearing will be conducted in the following order. We'll confirm that public notice has been proper. The city will present its case and staff report, and the applicant may ask questions of the city's representative. The applicant will present his or her case supported by witnesses and evidence, and the city may cross-examine each witness. Public comment will then be solicited or received from parties directly affected by the variance. Individuals testifying do not have the right to cross-examine the parties. All public comment shall be limited to 3 minutes per person. Public participation will then be closed. I will deliberate and then make a decision to grant or deny each variance requested in the applications. Formal rules of evidence do not apply to this proceeding. However, I will exert every effort to ensure that fundamental fairness is afforded to all parties. After my decision today, I will issue an order. The order will be reduced to writing, and the applicant will be provided with a copy by mail. Therefore, please make sure that we have your correct current address. Additionally, you are advised that I do not have the authority to grant you a building permit. You still must obtain a building permit for any work you intend to do on your property. If you wish to present any information to me today, it is necessary that you swear or affirm that you will tell the truth. Therefore, in just a moment, the city attorney will administer the oath and swear in any witnesses. If you expect to talk to me today during the hearing on any variance, then you need to rise and be sworn. This includes any members of the public who are directly affected by the variance and may wish to provide public comment. Mr. Trask, can you please go ahead and swear everybody in?
If everyone please stand, raise your right hand. I'm going to be sworn under oath. Swear that the testimony you're going to give today is going to be the truth, the whole truth, and nothing but the truth.
Yes, I do.
Thank you.
All right, the first matter on the agenda today is variance VAR 2022-05 for the property located at 13411 Boca Ciega Avenue. Is the city ready to proceed?
We are.
Go ahead, Mr. Trask.
We're going to call Andrew Morris as the city's witness. Andrew, if you could please state your job and your job responsibilities here at the City of Madeira Beach.
Hi, my name's Andrew Morris. I'm the planner and GIS technician. One of my tasks, I have to do the staff reports for variances.
Okay, how long have you been working for the city?
Since November of 2019.
Okay. Are you familiar with this first application filed by James and Shannon Sullivan?
I am.
Okay, if you want to go ahead and proceed then and present staff's presentation.
Okay, thank you. So this variance request is to build a private dock that extends more than 1/2 the width and outside the center 1/3 of the property at the waterfront. Background, variance 2022-05 for 13411 Boca Ciega Avenue would allow the construction of a private dock that extends more than 1/2 the width and outside the center 1/3 of the property at the waterfront. In the Madeira Beach Code of Ordinances, section 14-205, design criteria for private docks allows for property owners to apply for a variance for a proposed private dock. A variance request for a private dock must meet the requirements located in the variance section of the Madeira Beach Code of Ordinances. Physical and environmental constraints at 13 411 Bocasia Avenue, make building a private dock shorter than one-half the width of the property at the waterfront and within the center one-third of the property of the waterfront, not feasible. Next section is the variance criteria, where the first one is special conditions and circumstances exist which are peculiar to the land, building, or other structures for which the variance is sought and which do not apply generally to the lands, building, or other structures in the same district. Special conditions to be considered shall include, but are not limited to the following circumstances. Substandard or irregular shaped lots, if the site involves the utilization of an existing lot that has unique physical circumstances or conditions, including irregularity of shape, narrowness, shallowness, or the size of the lot is less than the minimum required in the district regulations. B, significant vegetation or natural features, if the site contains significant native vegetation or other natural features. Residential and neighborhood character, if the proposed project promotes established historic or traditional development pattern of a block face, including setback, building height, and other dimensional requirements. Public facilities, if the proposed project involves the development of public parks, public facilities, schools, or public utilities. Architectural and/or engineering considerations, if the proposed project utilizes architectural and/or engineering features that would render the project more disaster resistant. So staff findings are, relates to A, the lot at 13411 Bocasia Avenue was platted in 1935. The lot and setback requirements for the R2 low-density multifamily residential zoning district did not exist at the time the plat was created. The lot width of 39 feet does not meet the minimum lot width for a single-family home in the R2 zoning district. The lot is also regularly shaped. There is an oyster bed with shallow water that extends around about 30 feet beyond the seawall. During low tide, the water can recede to around 20 to 25 feet. The oyster bed and shallow water make building a dock without getting both neighbor signatures or a variance not possible. The allowed dock length without a variance or neighborhood signature is 23.5 feet and would not be usable. Next finding would be adjacent to the waterfront of 13411 Bocasia Avenue are oyster beds that extend out approximately 30 feet. It would not be possible to build a dock without needing a variance because of limitations caused by the oyster beds. Other nearby properties to 13411 Bocasia Avenue has similar physical constraints that would require a variance or the sign-off of adjacent properties to build a new dock. The proposed dock would fit the character of the neighborhood, and other adjacent properties have similar sized docks. A new dock would be built to all other current requirements for private docks in the Madeira Beach Code of Ordinances. A new dock would be more disaster resistant compared to older docks nearby. Next criteria is 2, the special conditions and circumstances do not result from actions of the applicant. A self-created hardship shall not justify a variance. Staff findings are the existing physical and environmental constraints at 13411 Bocasia Avenue were not self-created hardships. Other nearby properties have similar constraints due to irregular shaped lots, shallow water, and oyster beds. Okay. Next is 3, granting the variance will not confer on the applicant any special privilege that is denied to other lands, buildings, or structures in the same zoning district. Findings, other neighboring properties have similar physical and environmental constraints and would require either a variance or adjacent neighbors to sign off on building a new dock. Since other nearby properties in the R2 zoning district already have similar sized docks, granting a variance will not confer the applicant any special privilege that other properties in the R2 zoning district lack. Next one is 4, literal interpretation would deprive the applicant of the rights commonly enjoyed by other properties in the same zoning district under the terms of land development regulations, subpart B of this code, and would work unnecessary and undue hardship on the applicant. Staff findings are it would not be possible to build a usable dock the length of one half of the waterfront lot width of 13411 Boca Ciega Avenue. Other neighboring properties have similar docks to what is being proposed, since they also have similar challenges. A literal interpretation of the code section 1420-205 would deny the applicant the rights commonly enjoyed by other nearby waterfront properties in the R2 zone district. Next part of the criteria is 5. The variance granted is the minimum variance that will make possible the reasonable use of the land. Granting variance 2022-05 would be the minimum variance to make it possible for a reasonable use of the waterfront portion of 13411 Boca Ciega Avenue. The proposed dock would be of similar length and size as neighboring docks. Next one is, the granting of the variance will be in harmony with the general intent and purpose of the city land development regulations, and such variance will not be injurious to the area involved or otherwise detrimental to public welfare. Staff findings, variance 2022-05 will be in harmony with general intent and purpose of the city development regulations by allowing for reasonable waterfront access that other neighboring waterfront properties currently enjoy. The proposed dock would fit within the character of the neighborhood and would not be detrimental to the public welfare of neighboring properties. Staff recommendations. Staff recommends the approval of variance 2022-05 to build a private dock that extends more than one half of width and outside the center 1/3 of the property at the waterfront of 13411 Boca Ciega Avenue. Attached to it, I do have the public notice that was mailed to properties within 300 feet and posted at City Hall, the library, at the property, and on our website.
Mr. Morris, have you had the opportunity to review the rest of the agenda packet, starting at page 3 and running through page 42 of the agenda packet?
I have.
Okay. Are you asking the special magistrate to receive these documents into evidence?
Yes, I am.
Okay. All right. I would, at this point, I have no other questions of Mr. Morris. I would tender in evidence the exhibits starting at page 3 and ending at page 42 of the agenda packet.
All right, I'll go ahead and accept into evidence as exhibit number 1, the portions of the packet that start on page 3 and end on page 42. Mr. Morris, just a couple quick questions. If you can go to the photographs that I think start on page 13. Go through 18. Were these all provided by the applicant?
Yes, they were.
Okay, I didn't know if any of them were prepared by the city. On page 18, there's a graphic that shows signed confirmation of no objection, and it lists several homes. To the best of your knowledge, I understand this is provided by the applicant, does the city have the signed no objection to those properties that are identified with the check mark?
We had one resident that wanted to rescind their signature from that, and they sent in a notice of intent.
Okay. And I do have that, so I'm good there. All right, is there anyone here on behalf of the applicant, or the applicant's here? Anyone here? All right, come on forward, whoever wants to talk. And what is your name, ma'am?
Shannon Sullivan.
All right, and your name, sir?
James Sullivan.
All right. Okay, either of you are welcome to ask Mr. Morris any questions you want to ask. In a few minutes, I'm going to give you the opportunity to come up and tell me whatever it is you want to tell me to consider. As you heard, Mr. Morris is recommending that I approve the variance. However, you have the right to cross-examine, which means the right to ask him questions. So at this point, do you have any questions you want to ask of Mr. Morris?
Oh, just one, the one note of the rescind signature, when that came in, what date that came in?
Let me, just put there.
I believe it was yesterday.
I'm gonna find the. I have the notice intent that was turned in, on October 17th, 2022. From, Robert Arroyo.
Perfect. Okay, thank you, Andrew. And then per public record request, we had saw that the notice to rescind that was just yesterday. So just wanted to note that time. Otherwise, I have no questions, and I appreciate the staff for their support and effort and time for the application. Thank you.
All right, you guys have a seat. I'll call you back up here in just a moment. Mr. Trask, do you have anything else, any other witnesses?
I don't have any other witnesses, but I want to bring to your attention that the city has received a notice of intent to be an affected party by Robert Arroyo at 13433 Bogosiega Avenue. The city has also received a notice of intent to be an affected party from Tim and Kim Church. Their address is 13413 Bogosiega Avenue. And the city has also received a letter of support from Alex Archibald on, looks like the 18th of October. And then lastly, as I walked in today, I was handed a printout from Tim and Kim Church. They are one of the affected parties, a packet of information that was provided today as well. So I just want to make sure you have all of those documents available to you.
I do. I have a few different things. I want to make sure I'm looking at everything that the city has. I have a letter, or excuse me, an email from a Sarah Myers dated Friday, October 21st, 2022 at 5:52 p.m. It doesn't appear to state a position one way or the other. It just says they received a letter for the doc variance hearing and will be traveling and not attending in person and wanted to appear virtually. I see the notice of intents that you identified. I do see the letter of support that was sent to the mayor by Mr. Archibald, and I have the email from Mr. Arroyo, two emails from Mr. Arroyo, one on Friday, October 21st, 2022, one on October 23rd, 2022, as well as the what appears to be 32 pages plus an order granting variance that was provided by Tim and Kim Church that I have reviewed. Is there anything else, Mr. Trask, that you're aware of that I didn't just mention?
No, but I just want to make sure that we both understand that Sarah M. sent the email. She doesn't reference which variance application, and there are two variance applications for docs. So I'm not sure whether or not this is with regard to the first case or the third case. But she wanted to attend by Teams or Skype. She may have joined in by Zoom. She was provided with the Zoom. It's my understanding.
All right, I see a Sarah Myers on page 36. Her address appears on the parcels. So I'm going to assume it's 5A unless the city staff tells me, or agenda item 5A unless the city staff tells me it's something different. Because I do not see, I don't see her name listed on the the other dock variance matrix.
There is a Sarah Myers on page 20 of the application, on the packet.
Okay. All right, and that page is a certificate of no objection, so I'll note that for the record.
Okay.
And since I referenced it, I'll mark her email exhibit number 2. All right, Mr. Trask, any other witnesses on behalf of the city?
No, thank you.
All right, Mr. and Mrs. Sullivan, now is your opportunity to come forward. You can provide to me any information that you'd like to provide. You can call any witnesses you'd like to provide. You can give me any documents you want me to consider, anything like that.
Okay, thank you. Just want to say, per the city staff recommendation to grant this variant, this shows this request complies with all the variance requirements. We wanted to highlight some of those key points in context today, if that'd be okay. So the variance for this dock plan, 56-foot dock with a 3-foot lower step, is shorter than the next closest home with a dock, which is 2 doors down. That's 61.5 feet. This does not provide us with a special privilege. Of the 9 lots on the same block, all of the docks besides ours, 8 of them required a variance. The dock that did not require a variance is on an 84-foot wide lot, which is a double lot and much deeper at the water at low tides than our lot. For the hardship of the narrow plat, this land was platted in 1935, and it shows that the dock code was instated in 1983. Therefore, clearly, it didn't account for the original plot constraints. And that clearly predated our ownership in 2019. With 47 foot of seawall, and without this variance, it would only be permissible to build a 23.5 foot dock. That would be unusable for the purpose of having a dock in this area due to natural vegetation and shallowness. There are 56 homes and 55 docks on the water side of Bocaciag Avenue. An estimated 52 of the 55 docks on Bocaciag Avenue required a variance as well. The variances were obtained on those existing 52 docks, and they were needed to construct a usable dock in line with the customary use and enjoyment of properties in this area. In addition, 5 plus, now 4, adjacent water-facing neighbors signed the no objection to this dock variance. Also, there's a Pinellas County approved water and navigational permit placard as of June 17, 21 for the exact design requested by this variance, illustrating that this proposed plan adheres to the county requirements.
And I just wanted to add a couple of things for context as well beyond what was in the application. There are 2 things that you might find odd with this application being requested. Number one, not sure, but this may be the first time a variance application already has an approved county permit placard associated with it, as well as the prerequisite city stamp of approval for the exact plan being applied for today. If you were to look up our property on Pinellas County Property Appraiser, you'll see that there is a recorded dock permit on our property for this exact plan. The sole reason we're moving through this avenue is due to one of the 2 neighbors who rescinded their variance signature a full 2 years after it was originally signed. However, it was just before we could pick up our physical copies of those permits, and that's the sole reason why we purchased this property. We obtained both adjacent neighbor signatures ahead of the lot purchase, so this is how we've kind of gotten to this stage. The second odd thing that you might find on about our property is that it is the only house on the street that doesn't currently have a dock. So there is an unusual hardship created if we are denied the ability to build a dock suitable for a boat lift. And as Shannon stated, the next closest home that has a boat lift, their dock is 61 and a half feet long. The requested dock that we are requesting is 56 feet long plus a 3-foot lower platform in order to access the same similar water depth as that next closest house with a dock and a boat lift. And last, I would ask that if anyone besides the one adjacent neighbor have any affected party comments opposing to this being approved, I would ask that we look on a map as to where they are in proximity and if they even are on the waterfront to see if their comments are truly relevant and if they are truly an impacted party or if they're simply a friend or a business partner or something else there. As you can see, every neighbor but one in the immediate proximity supports this variance. Thank you very much.
All right, you guys stay there for just 1 second. Mr. Trask, do you have any cross-examination for either of the applicants?
No, I do not.
And Mr. Trask, Mr. Valdez, I have 2 more points, if that'd be okay.
Okay, sure. I'm sorry. I
for the
thought you were
flip-flop.
done. Yeah, no
We wanted to
problem.
hold your attention with the different voices. 2 quick points for you, sorry. The tide pictures included in the packet, those pictures were taken in June of 2022. That is an example of a low tide. I would like to tender into evidence 2 more pictures.
Just show them to Mr. Trask, and then I'll go ahead and accept them into evidence.
Okay, thank you, sir. This would be July 11th of 2022, August 10th of 2022.
Thank you.
These are examples of low tide. This is not every low tide of every day, but they are examples of low tide. Clearly, that would be a very difficult dock to build without the extending more than half the seawall as well as a third of the property.
All right, I will go ahead and accept into evidence as exhibit number 3, the 2 photographs that you provided that show the low tide. Is it July 11th, 2022, and then August 10th, 2022?
That's correct.
Okay, I'll go ahead and accept those into evidence, and they'll be exhibit number 3.
Thank you, sir. And lastly, our plan and provided, and want to note that it is customary for a dock contractor to draw out a plan on an application, a CAD or a blueprint type drawing, or again, CAD, computer assisted design. It's not customary. We built our house with an architect hand-drawn plan. So I want to just note that the included plan notes all the specifications per the code, lists out the specification and the distances per Article 5 marine structures, specifically Division 2 for the permit. It does sufficiently contain specifications and plans for the structure. And that's the last note I have for you today. Thank you.
All right, thank you. I think I jumped the gun on the last one. Mr. Trask, do you have any cross-examination based upon Ms. Sullivan's additional comments?
No, but she did hand me a 3rd piece of paper. Are you wanting to submit that into evidence as well?
Sure, you can tender that in evidence as well.
Well, I'll let you tender it, but I have no
Okay.
objection.
What is it? Can you tell me what it is?
Absolutely, it is just as I mentioned, the plan, and it's an
Oh,
overlay on
gotcha.
an actual Google map.
Okay, I'll accept into evidence as exhibit number 4, the overlay with the proposed structure drawn in.
That's perfect, thank you, sir.
All right. All right, is there anything else you'd like to tell me or share with me at this point?
No, thank you.
All right, I'm going to give you a chance to come back up after public comment in case there's anything you want to address during public comment. But if you wouldn't mind, you just have a seat right now, and we'll go ahead and get into public comment.
Okay, thank you.
All right, now is the portion of the hearing where any members of the public who are affected by this variance application can come up and speak. You have 3 minutes to tell me whatever it is you want to tell me. If you want to give me documents, you want to give me information, I'm certainly willing to accept that. So we're going to get through everybody, so there's no reason to rush or anything, but we'll go ahead and open public comment. So does anyone in the public want to comment in regard to this variance 2022-05 for the property located at 13411 Boca Ciega Avenue? All right, sir, come on up and just give me your name and address, please.
My name is Tim Church. I'm at 13413 Boca Ciega Avenue. We're the next door neighbor to James and Shannon, just to the north. I had prepared a bunch of information, didn't know it was going to be limited to 3 minutes, but so I hope to be able to go through that information with you. Since I'm certainly can't get through that in 3 minutes, I'd like to just touch on a couple of maybe the high points that I hope that you'll consider. Before I get into it, I will say that we do not want to keep James and Shannon from having a dock. We totally agree that they absolutely need to have a variance to have a reasonable, usable dock. The issue that I think that we have is at a total of 59 feet. Compared to our 49 feet, their dock will be more obtrusive, larger than it needs to be, and further out, frankly, than it needs to be. When I went through the application packet that the applicant submitted, I frankly saw just various false and misleading claims in there that paint a picture that's not totally accurate. Probably the one that jumped off the page to me first is on page 22. They show a hand drawing of what they plan for their dock to be next to the two adjacent docks. They omitted the length dimensions from the two adjacent docks. And I realize they don't need to include those as part of their dock plan, but when they're seeking variances from their neighbors, it makes it look almost as though their dock is of similar size, when in fact it's 24% longer. One of the things I would ask is that, as a neighbor, if I'm going to give them a variance, could we get some professional drawings at some point? Because again, we truly don't want to keep them from enjoying this area, having everything they need to get their boat in and out. Another thing that I took issue with is the picture, and now I guess some additional pictures that have been submitted of the very low tide. Not to run too far down a rabbit hole, that happens 24 times a year at the time that the sun and moon are opposite and that they're 90 degrees to the earth. It's not a daily impact at all. One of the things I included in my packet was what would an average daily tide would look like and pictures of it receding and coming back in. It's known as a spring tide, but just to not have any confusion, that doesn't mean spring like the season. That happens 24 times a year, and on average, usually about half of those will happen during daylight hours. They also, in their application, make a claim that the neighbor to the south has some concrete reinforcement to the riprap at their seawall, and that has created an unusual circumstance, possibly of deposited sand and sediment behind their property. If we look at some of the pictures that they also include, you'll see that that's not the case, that the shoreline extends to the properties on either side, so including mine and including the one on the other side of there. So I would just submit that there's not an unusual circumstance happening there, and it's a frankly speculative claim to say that thing over there is causing an issue here. The application also calls out the 61.5-foot dock at 13407 Boca Ciega Avenue. That is the only dock and the only seawall in the area that has a really unique circumstance. And I don't know if you can tell from the picture, but what that dock does, straight line like everyone else's dock, then it does about 125 or 30 degree angle out to create 62 feet of seawall. That bump out, which I've included pictures and measurements in some of the stuff that I've included, is another 14.5 feet further than anyone else's seawall. And so they had to get past that by 13 feet to get to that total 61.5 feet. The dock itself, to the point that it hits their, the front of their lift, is right at, I think, 48 feet, if I recall. I don't have the document in front of me, but I've provided it. I've also provided documents use Google Maps and the Google measuring tool, so I will say that within a few inches or even maybe a quarter of a foot might not be accurate because it's relying on my mouse clicking. But if we look at the measurements of all of the docks along there, 48 feet or less is typical. And so what I would submit is we want James and Shannon to have easy access to the water like everybody else. It doesn't take 59 total feet. It takes about 48 feet. And at that length, they're not impeding our view, which is something, the reason we bought the property, so we are one of the ones without a boat lift, because we're out there to enjoy the view. What they're proposing that they build, because the drawings aren't professional, they're missing various dimensions, and they're not to scale, it's just frankly difficult to make a well-informed decision on whether that particular build that they're applying for is a good idea or not. What I would ask, as the most closely affected party, is that they build their dock parallel to the property lines, that they keep it at a length not exceeding 48 feet, and they try to minimize the encroachment outside of the middle third of their property. Right now, they're proposing that by making the dock not parallel to the property lines, if I can try to illustrate this with my hands, if I've got the property lines here, and I've got the dock here, and here's my property, if they angle it, once they put a boat on it that sticks out further, that's just further encroachment. Where if they make it parallel to the property lines, then that doesn't cause an issue for me. So parallel to the property lines, 48 feet in length, which they would still absolutely need a variance that we would be more than happy to grant, and just minimal encroachment on that middle one-third. I think I maybe want to add one last thing and then wrap up my points. The last thing is the people that have signed the approval for them to do this, none of them live here, including Myers, which is the applicant's parents and in-laws. They've relocated, they've moved for a job to, I believe, Maryland. I don't know that that matters or not, but I do know that the people signing saying, hey, that's okay with me, are people that they're not affected by it. So I would just submit that for consideration. And that finishes my comments. Thank you.
Great, thank you, Mr. Church, and I do want you to know that I have reviewed the entirety of the comments that you provided as well.
This is Sarah Myers. I was wondering if you could hear me?
Ms. Myers, I can hear you, and
Yes.
so can you give me your address, and then you tell me whatever it is you'd like to tell me.
We're at 13435 Boca Ciega Avenue, and we did not move. We are back and forth temporarily. We're going to be back in November. We're going to be back in January. We're going to be back in March. This is just a temporary issue that my husband will be here working, and I decided to come along with him. But again, we will be traveling back. Our homestead is there. This is just a temporary location for it to be convenient for his work, and this is not a permanent address. We are not affected by the dock, and we had similar issues with the tide and had to go out further and got variances from both of our neighbors. Thank you.
All right, so I take it, Ms. Myers, you're in support of the application, is that correct?
My husband, Ken, and I, Sarah and Kenneth Myers.
All right, thank you, Ms. Myers.
You're welcome.
Is there anyone else present here in chambers that would like to speak on this issue? All right, come on up, ma'am. Oh, come on, it's okay. We're going to make time for everybody, don't worry. All right, ma'am, what is your name?
Kim Church.
All right, Ms. Church, what would you like me to know?
I just wanted to reiterate what my husband said here. I don't think he really missed much. I appreciate your going through the application package there. We spent a lot of time pulling that together. I do want to reiterate that our main point is we agree we do want the Sullivans to have a variance, but we don't want them to have an unfair variance. So if every other home has that 48 feet, that 61 foot notwithstanding because of the way that shoreline is jutted out there, I don't think that it would be fair to give them a 59-foot dock, and I don't think it should be angled away from that parallel line because that's when we're getting, our views being obstructed. So we agree overall with the city saying, yes, grant a variance. We're asking for it to be minimized and reduce the impact on our view and our property.
Thank you, Ms. Church.
Thank you.
All right. Is there anyone else in chambers that would like to come up and speak?
Hi, my name is Laura Sigaloff. I am reading in case Sarah and Ken Myers were not able to join Zoom. So the following comments are read on behalf of Ken and Sarah Myers, owners of 13435 Boca Ciega Avenue. We support the residents of 13411 Boca Ciega Avenue to build the presented dock and boat lift as it is reasonable and fair. Having a dock and lift is the norm for most waterfront homes in this area. One of the main attractions of Madeira Beach is the ability to have a dock and to be able to enjoy boating. Bottom line is that if you are a boat owner and are interested in building and the lot does not already have a dock of sufficient length to support your boat, you are left to the discretion of the neighbors without this special magistrate process. Neighbors may have a conflict of interest and/or don't need to have any reason to sign a variance, even if they have a dock themselves that also had to have approval by the neighbors at the time. It is without a doubt that this application meets all criteria for a special magistrate variance approval because the requested dock is in line with surrounding docks and the closest dock with a lift is longer than this dock being requested here. It would actually be an anomaly and unusual for this area if a dock similar to this specification was not approved. Thank you.
All right. And ma'am, how do you spell your last name?
T-S-I-G-U-L-O-F-F.
I am sure glad I asked, because that's not the way I had it spelled. Thank you, ma'am. Okay, is there anyone else in chambers today that would like to address this first application? Anyone else? All right, I'm going to close public comment. Mr. Trask, I'm going to go to you first and see if there's anything else you'd like to tell me, and then I'll give the applicants one last chance if there's anything else they want to tell me.
I just want to make sure that there's no one else that is attending by Zoom other than Ms. Myers, who attended. Mr. Arroyo said that he wanted access by way of Zoom.
Is there anyone else who's appearing by Zoom or by some other video manner that wants to provide any information to me today? If you do,
Yes.
please speak up now.
Yes. Hello.
Okay, who is this?
Hi, my name is Lori Souza, and I'm here for the Brian Murray 14033 Parsley Drive.
Okay, so that's down the line, ma'am. We're here on variance number 22-05 for the property at 13411. So, ma'am,
Sorry.
if you want to just stay on, because we're going to get to that later on down the agenda. You're in the right place, you're just not at the right hearing yet, so sit tight.
Okay, thank you.
Is there anyone else who is appearing virtually that wants to say anything to me about variance 2022-05 for the property located at 13411 Boca Ciega Avenue? Okay, I didn't hear anyone speak up. And is there anyone, one last call, anybody here in chambers that wants to speak to me about variance 2022-05 for the property located at 13411 Boca Ciega Avenue? All right, hearing none, I'm going to go ahead and close public comment. Mr. Trask, is there anything else you'd like to tell me on this variance?
No, I don't have anything else. Thank you.
Mr. and Mrs. Sullivan, is there anything else you'd like to tell me in regard to this variance?
Sure, I just have a couple of things. So one of the items that was referenced was the length of the adjacent left neighbor dock. If you look at the approved permit on his dock that also required a variance, the total length of that dock is 50.5 feet, not 49 feet. The other point, I'm actually glad it was brought up, if we go back to that visual that was referenced for the dock that is 61.5 feet long, that also has a very unique situation with that angled seawall. So you can see right there where the dock is 61.5 feet and has that angled kind of parallel to the property line seawall that extends out. The impact of that unique scenario doesn't only impact that one resident there. Because of the way the water goes in and out with the tides and the silt that's built up due to that projection there, that doesn't just impact his lot, that impacts the next one and ours and even following until you finally get past the furthest left lot that you can see in that picture. Once you get past there, the impact of that extended shoreline goes away. But each house you carry to the north, it gets a little bit less, but there is a true impact to our property due to that protrusion of an angled seawall there.
And I think the image up right now kind of portrays that. There's a aerial view showing clearly at that point there was a low tide. So that capture of all that sediment does not just impact that one 61.5 foot. Also, the starting part of both our dock and the 61.5 are at the same. You can see again, the shallowness is attributable and evident at all of those 4 or 5 lots right there.
All right, thank you. Anything
you.
else?
That's it for today. Thank you.
All right, we'll go ahead and close the hearing on variance 2022-05-13411. Based upon the submissions provided by the applicant, the city staff report, the testimony provided, I'm going to go ahead and grant the variance as submitted. I'll go ahead and get an order out in the mail to you guys, so make sure that you have a good address. I'm going to send the order to 13411 Bocasiega Avenue. I think that's the right address to send it to. All right, so I'll go ahead and grant that variance. You'll get an order out in the next few days. Let's move on to variance number 2022-06 for the property located at 431 137th Avenue Circle. Is the city ready to proceed on that?
Yes, we are.
Go ahead, Mr. Trask.
So in this particular case, we're going to have Andrew Morris again testify on behalf of the city. Andrew, just going to repeat some of these questions that I had in the previous application in case this one is appealed, just like the other one. If you could state your name and your job responsibilities here at the city of Madeira Beach.
Hi, my name's Andrew Morris. I'm planner and GIS technician for the city of Madeira Beach. I was hired in November of 2019. One of my tasks, I do have staff reports and review variance applications the city receives.
Okay. Are you familiar then with this variance application 2022-06 for the property located at 431 137th Avenue Circle?
I am.
Okay. If you could go ahead and proceed then with your presentation of the staff review of the application.
So for variance 2022-06, the request is a variance request to reduce the front setback from 20 feet to 13 feet and reduce the rear setback from 25 feet to 15 feet. The specific variances for the specific code provisions of the setback requirements for the R2 zoning district, sections 110-206, front yard, which is 20 feet, and then section 110-2062, rear yard, which is 25 feet. For the background of this variance, the variance request for 431 137th Avenue Circle reduces the front and rear setback to allow for the construction of a new single-family home. The proposed home would meet the required side setbacks, which the current home doesn't meet, and all the other requirements in the R2 low-density multifamily residential zoning district. The existing home and lot are legally non-conforming since the lot plat was approved in 1941 and the home was built in 1945, which predates the zoning codes. Next section is about the variance criteria from the Madeira Beach Code of Ordinances. And the first part of that is special conditions and circumstances exist which are peculiar to the land, building, or other structures for which the variance is sought and which do not apply generally to the lands, buildings, or other structures in the same district. Special conditions to be considered shall include but are not limited to the following circumstances. One of the ones that relates to this property is the a substandard regular shaped lot if the site involves utilization of existing lot that has unique physical circumstances or conditions, including irregularity of shape, narrowness, shallowness, or the size of the lot is less than the minimum required in the district regulations. Under staff findings, the lot at 431 137th Avenue Circle is an irregular shaped lot that does not meet the current minimum lot size requirements for the R2 low-density multifamily residential zoning district. The lot plat was approved in 1941. The house was built in 1945, making the lot legally non-conforming. The R2 zoning district requires a minimum lot size of 4,000 square feet. The lot for 431 137th Avenue Circle is approximately 2,563 square feet. The lot does not meet the required lot depth of 80 feet. Both the lot plat and house predate the current zoning requirements. The lot and home at 431 137th Avenue Circle are legally non-conforming. The next part of the criteria it meets is a C, residential neighborhood character, if the proposed project promotes the established historic or traditional development pattern of a block face, including setbacks, building height, and other dimensional requirements. Staff findings, the surrounding properties near 431 137th Avenue Circle were also platted in 1941. Since nearby lots predate zoning, many of the lots near 431 137th Avenue Circle are regularly shaped, non-conforming size lots. Many of the older nearby homes are legally non-conforming, and they don't meet the current setback requirements since they were built before the zoning was established. This proposed project fits within the established character of the neighborhood since nearby lots were platted at the same time and have similar challenges with irregularly shaped lots. The last part is E, architectural and/or engineering considerations if the proposed project utilizes architectural and/or engineering features that would render the project more disaster resistant. E, the existing home is a slab-on-grade home and the living space is on the ground floor. The current home would be at risk for flooding during like a flood event like a hurricane. A new home would be built to the current FEMA requirements that would make the structure more disaster resistant than the existing home since the living space would have to be built above base flood elevation plus 4 feet of freeboard. The next part is the special conditions and circumstances do not result from the actions of the applicant. A self-created hardship shall not justify variance. Staff findings, the home at 431 137th Avenue Circle was built in 1945 and predates current zoning requirements. The lot was platted in 1941. Since like both the home and the lot predate the creation of the R2 zoning district, and both the home and lot are legally non-conforming, they're not self-created hardships because it happened way before the current owner bought the property. 3, granting the variance will not confer on the applicant any special privilege that is denied to other lands, buildings, or structures in the same zoning district. Under staff findings, since the lot at 431 137th Avenue Circle and nearby surrounding properties were platted in 1941, many nearby properties have similar setbacks because of the regular shaped lots that predate zoning. The new home would meet the side setback requirements that the existing home doesn't currently meet. Granting the variance would not give the applicant any special privileges. Next part of the criteria is 4. Literal interpretation would deprive the applicant of rights commonly enjoyed by other properties in the same zoning district under the terms of the land development regulations subpart B of this code and would work unnecessary and undue hardship on the applicant. Under staff findings, when the front setback and rear setback, section 110-206, 1 through 2 for the R2 low-density multifamily residential zoning district are laid over the existing lot, allowable buildable area would not allow for a single-family home to be built. A literal interpretation of the front rear setback requirements would deprive the applicant of the rights commonly enjoyed by other properties in the same zoning district. Next part of the criteria, the variance granted is the minimum variance that will make possible the reasonable use of the land. Under staff findings, the variance granted would allow for a new structure to meet all the current requirements in the R2 zoning district. Building a new single-family home would be a reasonable use of the land. The granting of the variance will be in harmony with the general intent and purpose of the city land development regulations, and that such variance will not be injurious to the area involved or otherwise detrimental to the public welfare. Under staff findings, granting variance 2022-06 is in harmony with the general intent and purpose of the city land development regulations. The proposed reduction in front and rear setback would allow for the construction of a new home that would meet all the other current requirements for a single-family home in the R2 zone district. Variance 2022-06 would not be detrimental to public welfare and would not have a negative impact on nearby properties. Staff recommends the approval of variance 2022-06 to reduce the front setback from 20 feet to 13 feet and reduce the rear setback from 25 feet to 15 feet for a new single-family house. Attached to the staff report are the public notices that were mailed out to properties within the 300 feet and posted at the property, City Hall, and the library, and on our website.
Okay, Mr. Morris, I have a few questions for you. If you could turn to page 53 of the packet. I want you to look at the boundary survey on that page. You have it in front of you now?
Yes, sir.
Okay. And looking at this boundary survey, this is the as-built structure on the property right now, correct?
Correct.
And this is showing that on the right side of the property, between lot 85 and 86, that the side yard setback is 2.9 feet. Is that correct?
That is correct.
The proposed setback is going to be 5 feet on that side, correct?
Correct.
So the 5-foot setback then would meet code if it's, if that is the requirement for the side yard setback, correct?
Yeah, the minimum,
Minimum would be 5.
5 on each side, total 10 feet for,
Okay, and then if you look to the right side of Lot 85, adjacent to lots 81 and 82, it's reflecting a side yard setback of 4.4 feet between the property line and the building, correct?
correct,
So that's going to be corrected as well. It's going to be 5 feet, correct?
correct.
And as for the backyard, it's currently, the structure is 14.7 feet from the back property line. And this requested application or the variance is to actually make it less intrusive into the setback. It's going to be 15 feet. Is that correct?
That is correct.
Okay. And is that, if you could turn then to page 51 of the packet, and that's titled at the top of it, preliminary site plan. And is this the site plan that is being proposed for the new home on the property?
Yes, this had the setbacks that were being proposed. They still have to come through and get a building permit.
Understand. If you get closer to the microphone so everybody can
Oh,
hear you.
sorry about that. Yeah, this is just a preliminary site plan that showed the setbacks they were requesting the variance on.
Okay. So in this preliminary site plan, it just reflected the questions that I was asking you about the previous boundary survey. Is that correct?
That's correct.
Okay. Have you had an opportunity to look through the rest of the documents that are in this agenda item packet, pages 43 through 70?
I did.
Okay. And are you asking that the special magistrate receive this packet of materials on page 43 through 70 to be received into evidence?
I am.
Okay. All right. I have no other questions for Mr. Morris. I would tender into evidence the agenda packet, pages 43 through 70, to be received into evidence.
Mr. Trask, we'll go ahead and accept into evidence as exhibit number 1, the agenda packet from pages 43 to 70. Mr. Morris, I just have a couple questions for you. Will you look at page 55 of the agenda packet? It has some aerial photos, or at least one aerial photo and a front elevation picture. There you go. I assume these lots are all the neighbors, the subject parcels in the middle there?
Yes, sir.
It appears just by looking at my eyeball that both structures on either side would encroach into the 25-foot setback.
The house on the right was approved with a redevelopment, like in a couple years ago, where so they built a new house within the same like footprint of the existing house, which in our code you can apply for redevelopment, but that's why it's so the new house that's on the right, that's under construction in the picture, that's why it's the way it is, because it was an approved redevelopment where it was built within that setback.
Sure, and it looks like the house that is to the, if looking at the picture to the left, also appears to be closer to the setback than what's being proposed in this application, right?
That is correct.
Okay. Just trying to understand the character of the most immediate surrounding properties. All right, is there anyone here on behalf of the applicant, or is the applicant himself or herself here? Hello, sir, what is your name?
Good afternoon, hearing officer. My name is Todd Pressman, 200 2nd Avenue South, number 451 in St. Petersburg. I'm here today with Mr. Klaus, who is the property owner, presenting the variance request to you.
Excellent. Mr. Pressman, as we did in the prior hearing, I'm going to give you a chance to come up, tell me whatever you want to tell me in just one moment. Do you have any questions for Mr. Morris based upon his testimony?
No, staff report reads great. He's obviously looked at it very closely and raised a lot of important critical points.
All right. Stay there, because I don't know if Mr. Trask has any other witnesses, and if not, I'll let you go right into your presentation. Any other witnesses, Mr.
I
Trask?
don't have any other witnesses. I don't have any notices of intent or letters of objections or letters in support of this one. I just want to let you know that.
All right. Mr. Pressman, as you know, the staff is recommending approval. However, this is the point in the hearing where you can tell me anything you want to tell me. I have read in the entirety the packet, including the information, the documents that you prepared for submission. But is there anything you want to tell me, any witnesses you want to call, any evidence you want to provide to me?
No witnesses, but I do have a PowerPoint which the city has downloaded and is in front, if I may run through that.
Go ahead.
So this is variance 2022-06 from Mr. and Mrs. Klaus. They are in the R2 low-density residential medium zoning district. And as discussed, there's a reduction in the front setback and rear setback. And as Mr. Hearing Officer, as you noted, in regard to the front setbacks and the side setbacks, the properties abutting, as you pointed out, will, even with these variances, have more aggressive setbacks than what's proposed today. You've seen the boundary survey and the preliminary site plan. This is the plat from 1941, so we're dealing with a very old plat and how this area was developed in terms of plot lines. And you can see a number of unique and singular circumstances, just the shape of the road, not just a circle, but a tighting circle at the point of, close to the point where the Klaus property is. And that shaped and determined a lot of the lot lines to be very unique and singular in shape and design. And a little closer, you can see lot 85 as it exists, and it was a reflection in 1941 as the plat was drawn up in that point. And this is an aerial which you saw a little closer on the photos. And this is a street view, and as you've recognized, the smaller lower house is the subject property variance with the home next door, and just a view up the street. So you've heard a lot of comments from the staff. Just to highlight a few. The lot is legally non-conforming and was laid out in the plat in 1941, built in 1945, which predates the zoning code as of today. Staff notes it is irregular shaped that does not meet the current minimum requirements of the R2. And in the staff report, I think they made a very important finding, which is that if you were to lay the R2 standards on this lot, it would be unbuildable as a single-family home as it currently exists. The proposed project does fit within the established character of the neighborhood, as the staff has made that determination. The current home is a grade. I think this is an important point, that a new home would meet FEMA standards, particularly in regard to the last, or to the unfortunate recent events that have occurred to the south of us. This will raise the house to FEMA standards. Staff has indicated it's not self-created. There are no special privileges. The current R2 setbacks, again, would not allow for a single-family home and would allow for reasonable use of the property. It certainly is in harmony with the area. What they're seeking is a single-family home, which is what this area is. And I think the most pressing point, which I want to emphasize again, in support or test of a variance, is that no single-family home, again, could be built on this lot under the R2 today's standards. And what they're requesting, as you pointed out, on both abutting lots, is that what they're requesting is less than what is existing on the lots next to them. So with that and with the staff report and the PowerPoint presented, we appreciate your consideration and time today. Thank you. Happy to answer your questions you might have.
Mr. Trask, I'll let you go first. Do you have any questions for the representative of the applicant?
I do not.
Mr. Pressman, I don't have any questions, except for, I don't have a hard copy of your PowerPoint. Do you want to submit that as part of the evidence that I bring in today? And if you don't have a hard copy, I'll let you submit it after the hearing, but
I don't have
certainly
a-
listen to everything you said, but if you want to submit it as a hard copy, I'm happy to accept it into evidence.
Fine. I can send it by email. I can do it when I sit down and send that into the city.
That'd be great. I'll go ahead and, unless you have an objection, Mr.
No
Trask, I'll go
objection.
ahead and, okay, I'll go ahead and accept your PowerPoint as exhibit number 2. If the city staff, if you guys, once you got that, would please just put it in with the hearing materials that are submitted so that it is in the record.
Thank you.
All right. Okay, now is the time of this hearing for public comment. Again, for anyone who's out there on Zoom, the hearing that we're talking about is variance 2022-06 for the property located at 431 137th Avenue Circle. Let's start with those that are in chambers. Is there anyone physically present today that wants to provide any public comment in regard to variance 2022-06 for the property at 431 137th Avenue Circle? Going once, going twice. Okay. Is there anyone who is appearing virtually at today's hearing that wants to talk to me about variance 2022-06? Again, this is for the property located at 431 137th Avenue Circle. Hearing none. Mr. Trask, anything else?
No, sir.
Mr. Pressman, anything else?
No, we appreciate your time and consideration. I have emailed it again to the staff. Thank you.
Excellent. I'll go ahead and approve the variance as submitted. Mr. Pressman, do you want me to send a copy of the order to your business address or just to the property address?
Not the property address. If you send it to my business address, that would be fine.
The
Thank you.
200 Second Avenue South?
Yes, sir.
All right, I'll make a note of that. Thank you, sir. Okay, the next matter for consideration today is variance 2022-07 for the property located at 850 Bay Point Drive. Is the city ready to move forward on that one?
Yes, we are.
All right, go ahead, Mr. Trask.
The city would call Andrew Morris to testify on behalf of the city. Mr. Morris, again, I'm going to ask you a couple of questions. Your name, your entire name, please, your job responsibilities here at the city of Madeira Beach, and how long have you been employed here?
My name's Andrew Morris. I'm a planner and GIS technician for the city of Madeira Beach, and I've been working here since November of 2019. One of the tasks I do is I review variance requests and write up a staff report.
Are you familiar with the property located at 850 Bay Point Drive and the application, variance application associated with that property?
I am.
Okay, if you want to go ahead and present your staff report then, please.
The request for a variance 2022-07 is to install a lift adjacent to an existing dock. The elements will extend more than 1/2 the width and outside the center 1/3 of the property of the waterfront. The specific code provisions, the variance towards section of 14-205, design criteria for private docks. The background variance 2022-07 for 850 Bay Point Drive would allow construction of a boat lift adjacent to a private dock that extends more than 1/2 width of the property at the waterfront and is located outside the center 1/3 of the property width at the waterfront. In the Madeira Beach Code of Ordinances, Section 14-205, design criteria for private docks allows for property owners to apply for a variance if part of the dock or dock improvements extend more than one half the width and are located outside the center one-third of the property width at the waterfront. A variance request for installing a boat lift adjacent to a private dock will still need to meet the criteria for variances and other requirements for private docks in the Madeira Beach Code of Ordinances. Next part is the variance criteria, section 2-507B, and analysis. First part of that is special conditions and circumstances which are peculiar to the land, building, or other structures for which the variance is sought, and which do not apply generally to the lands, building, and other structures in the same district. Special conditions to be considered shall include but are not limited to the following circumstances. A is a substandard or irregular shaped lot if a site involves the utilization of an existing lot that has unique physical circumstances or conditions, including the irregularity of shape, narrowness, shallowness, or the size of the lot is less than the minimum required in the district regulations. Under findings, the plat for 850 Bay Point Drive was approved in 1952. Many of the nearby lots have a width at the waterfront of 60 feet, but 850 Bay Point Drive has an irregular shaped lot where the land adjacent to the waterfront is more narrow than the nearby property. Since 850 Bay Point Drive has an irregular shaped lot, there are limitations to what can be constructed for private docks compared to other neighboring properties. The next part of variance criteria it meets is C, residential neighborhood character. If the proposed project promotes the established historic or traditional development pattern of a block face, including setbacks, building height, and other dimensional requirements. Under staff findings, the proposed boat lift fits the character of the neighborhood. The R1 single-family zoning district allows for residential docks as an accessory use. Other nearby properties have similar-sized boat lifts and docks. Many of the surrounding docks and boat lifts would require a neighbor sign-off or variance because they do not fit within the one-half the width and are located outside the center one-third of the property of the waterfront. The next part of that it meets is E, architectural and or engineering considerations. If the proposed project utilizes architectural and or engineering features that would render the project more disaster resistant. The existing private dock at 850 Bay Point Drive is located near the Intracoastal and on Boca Ciega Bay. The current private dock experiences wave action from boat traffic and wind. The wave action causes the applicant's boat to slam against the dock lane to damage to the boat. The existing mooring whips are not able to hold the boat in place because of the wave action. During a hurricane scenario with even stronger wave action, there is an increased risk of property damage to the applicant's property and surrounding properties because of the lack of a boat lift. Next part is the special conditions and circumstances do not result from the actions of the applicant. A self-created hardship shall not justify variance. The plat for 850 Bay Point Drive and other nearby lots were approved in 1952. The lot predates the design criteria for private dock requirements, which were not implemented until 1983. Other nearby properties are located near the Intracoastal and have similar issues with wave action and wind. These conditions are not self-created hardship from the applicant and have existed for decades. Next part is granting the variance will not confer on the applicant any special privilege that is denied to other lands, buildings, or structures in the same zonage. Other nearby properties have boat lifts, including some in similar locations. Granting this variance would not give the applicant any special privileges that is denied to other lands, buildings, or structures in the same zoning district. Next part is 4, literal interpretation would deprive the applicant of rights commonly enjoyed by other properties in the same zoning district under the terms of the land development regulations, subpart B of this code, and would work unnecessary and undue hardship on the applicant. Under staff findings, other neighboring properties have similar boat lifts to what the applicants are proposing because they have similar challenges. Literal interpretation of the code, section 14-205, would deny the applicant of the rights commonly enjoyed by other nearby waterfront properties in the R1 zoning district. The variance granted is the minimum variance that will make it possible the reasonable use of the land. Under staff findings, granting variance 2022-07 would would be the minimum variance to make it possible for a reasonable use of the waterfront portion of 850 Bay Point Drive with the current configuration of the dock. The proposed boat lift would be similar to other neighboring boat lifts. 6, the granting of the variance will be in harmony with the general intent and purpose of city land development regulations, and that such variance will not be injurious to the area involved or otherwise detrimental to public welfare. Variance 2022-07 will be in harmony with the general intent and purpose of the city development regulations by allowing for reasonable waterfront access that other neighboring waterfront properties currently enjoy. The proposed boat lift would fit within the character of the neighborhood and would not be detrimental to the public welfare of neighboring properties. Under staff recommendation, staff recommends approval of variance 2022-07 to build a boat lift as adjacent to a dock that extends more than 1/2 width and outside the center 1/3 of the property at the waterfront of 850 Bay Point Drive. Attached to the staff report are the public notice and posting pictures, and it was posted at the property, City Hall, and at the library and on our website, and it was mailed to property owners within 300 feet.
Thank you, Mr. Morris. Have you had the opportunity to review the entire agenda packet for this particular application as set forth in the agenda at pages 71 through 99?
I have.
Okay. And are you asking that the special magistrate receive these documents into evidence?
I am.
Okay. I tender into evidence pages 71 through 99 of the agenda packet.
All right, I'll go ahead and accept into evidence as exhibit number 1, pages 71 through 99 of the agenda packet.
I have no other questions of Mr. Morris.
All right, is the applicants here, anybody on behalf of the applicants present? All right, who wants to talk to me first?
I'll go ahead and speak, sir. We are the property owners of 850 Bay Point Drive, Richard Gish and Stephanie Gish. The only question I have for Mr. Morris, following submission of this variance application, our neighbors to the right did provide their letter of no objection. I just wanted to confirm that that had been provided to the magistrate for consideration.
And I can answer that, yes, it has, and Mr. Gish, Mr. Trask, unless you have an objection, I'll go ahead and accept into evidence as exhibit number 2, the letter of no objection for the property owner at 852 Bay Point Drive. Is that the one you were referring to, Mr. Gish?
Yes, sir.
Okay.
No objection.
All right, I'll go ahead and put that in the record as exhibit number 2. Mr. and Mrs. Gish, do you have any more questions for Mr. Morris? Again, I'm going to give you an opportunity to tell me any other evidence you want to tell me in just a moment, but do you have any other questions for Mr. Gish?
I have no
Mr.
further
Morris,
questions
sorry.
for this witness. Thank you.
All righty. Okay, stay right there because I don't know if Mr. Trask has any other witnesses or not.
I do not have any other witnesses, but I did want to bring to your attention that the city had received a notice of intent to be an affected party from Glenn and Margaret Gordon, 848 Bay Point Drive here in Madeira Beach. You've already dealt with his letter of support. I think it was, and that was all I had on that particular case. No other witnesses, so.
And I'll go ahead and just for purposes of the record, attach that notice of affected party as exhibit 3.
Okay.
All right, Mr. and Mrs. Gish, before I open it up to public comment, this is the portion of the hearing where you can tell me anything you want to tell me. Obviously, as you heard, staff is recommending approval of your variance. But is there anything you want to tell me, any witnesses you want to call, any evidence, documents, or anything you want to provide to me?
In the interest of efficiency, we'll refer to the fact evidence in our application. The only additional piece of fact evidence I'd like to convey, the Hurricane Ian storm event, while it did land about 90 miles south, it resulted in significant lowering of the water level here. That combined with the wave action and the winds, I can absolutely testify 100% to a reasonable degree of engineering certainty, our boat would have sunk had it been in the water. Luckily, we were able to utilize a nearby boat lift that was empty, and so it was protected, but it absolutely would have been destroyed. And it has sustained several $1,000s in damage already due to when large sport fishers or trawlers go by, being slammed into the dock, and it's just, in its current environment, not possible to keep the boat in the water there without sustaining further damage.
All right, thank you. And just like I did with the prior applicants, I'm going to give you guys an opportunity to come back up after public comment if you two want to address anything during the public comment. But for right now, you can have a seat.
Thank you.
All right, this is the portion of the hearing where we're going to accept public comment. Please remember, we're here on variance number 2022-07 for the property located at 850 Bay Point Drive. So we're just talking about public comment in regard to the property at 850 Bay Point Drive. We'll start with those that are physically present here in chambers. Is there any member of the public that wants to come up and provide any information to me in regard to the variance for 850 Bay Point Drive? All right, come on forward.
Can I give you some paperwork to support what I'm about to say?
Absolutely, but first give me your name and address.
My name is Margaret Gordon, and this is my husband Glenn. We live at 848 Bay Point Drive, right next to the Dishes.
All right, and I did get your notice of an affected person, so now, if you wouldn't mind, just show Mr. Trask whatever it is you want to show me.
Well, first of all, thank you for...
Hold on just one second, because I want, if you want to refer to that while you're talking to me, I would like to have it in front of me, but I want
Sure.
Mr. Trask to look at it first. All right, Ms. Gordon, I now have in front of me what you gave to Mr. Trask. It looks like it's a 3-page document.
Yes.
And this is your opportunity to provide to me anything you want to tell me about the property, the application, or anything like that.
Sure. Well, first, we'd like to say we have no intention of keeping the Gishes from boating. We want them to be able to have a boat lift. What we want and expect is for them to do it in such a way that it provides the least encroachment on our riparian rights. If you look at the way the dock is drawn now, the lift is entirely on our side of their existing dock, to the point where it almost touches our riparian property lines. In that email that I handed you, he had been open to looking at other alternatives, to perhaps moving the lift to the center of the dock and reconfiguring his current dock so that it would encroach less on our property lines. And you see in that email, he just decided that it was too costly for him to do that. So he broke off communication with us, and that's the last we heard until we received the notice that there was going to be this hearing. So we really don't want to prevent them at all from having a lift. We just want it to encroach far less upon our riparian right lines, because that could affect our property value and our ability to sell that house in the future. Do you have anything to
All right,
add?
thank you, ma'am. Mr. Gordon, anything you'd like to tell me?
No, I think she covered it. You'll see that the two emails there are
Just
really involving us and the Geishes, and also the previous owner that was there. His name was Tom
No,
Schaefer.
they don't have that email.
Oh, they don't have that email,
No,
I'm sorry.
I just gave them one. Yeah.
Okay. No, I think Meg covered it. It's pretty simple. We don't mind them having a boat lift. We encourage it. We have a boat lift,
Right.
but it doesn't need to take up all of the property over on our side. They can reconfigure their dock. It may cost them a little more money, but they can reconfigure it, and we can have more of our riparian rights in terms of that property.
All right. Would you like me to go ahead and attach this as an exhibit in the record?
If you would, please.
All right, I'll go ahead. I'm going to mark it as Exhibit 4, and I'll include it in the record today.
Okay, thank you.
Anything else you guys would like to tell me?
No, just thank you again for allowing us to speak.
Thank you guys for coming today. All right, again, we're here on public comment for variance 2022-07 for the property located at 850 Bay Point Drive. Is there anyone else? Okay, we have one other person coming up. You please give me your name.
My name is Jean Farnan, and I live at 574 Johns Pass Avenue.
All right, hold on. Jean, is it G-E-A-N, or how do you spell your first name?
Jean.
J-E-A-N, okay. And how do you spell your last name?
Farnan.
All right, and tell me again your address?
574 Johns Pass Avenue.
All right. Ma'am, what would you like me to know about this variance?
Well, first I want to say I am not an affected party to this particular variance. But I felt it was important because this is a new ordinance, and for things that you as a magistrate should maybe consider, because what you decide on these dock ordinances and boat lift ordinances sets a precedent. And I've lived in Madeira Beach on the water for a very long time. I've had elderly neighbors that were subjected to threats and retaliation for not signing variances, and with the intent as these people here had kind of pointed out, that when you have a variance like that, it affects your property, the value of your property forever, because once it's there, it's not going anywhere. And in this particular case, I mean, you do have a pie-shaped lot, but there is an existing dock there that is fairly new, and it is really a non-conforming dock. It's very long, and this is a man-made problem for them to, put a boat lift. It's right on the property line. When I looked at the drawings, I thought, that is a major encroachment, that the dock that's there, whether it is built in 2022 or built in 1985, that can be altered and to provide less encroachment to adjacent properties. And like I said, I think that the decisions you make in these variance hearings on this, it sets a precedent. And that's all I wanted to say. Thank you.
Thank you for your input, ma'am. All right, is there anyone else in the audience here today in chambers that would like to come up and talk to me about this variance in the property at 850 Bay Point Drive? Okay, seeing none. Is there anyone who is attending this hearing virtually online that would like to provide comment in regard to variance 2022-07 for 850 Bay Point Drive? Hearing none, we'll go ahead and close public comment. Mr. Trask, is there anything else?
Nothing else, thank you.
Mr. Miskish, is there anything else you'd like to add?
Thank you. I'll try to be brief. I've been a testifying expert for decades. I've never testified in a case where a ruling was made based on something that didn't affect this property at all by somebody who was also not affected, based on a prediction of threats or baseless statements of reduction of value for, especially in this case, for a property located on the Intracoastal Waterway, where just on our street alone, 56 of the 80 properties, including vacant lots, 56 have currently boat lifts, including several that, as we said, are almost identical to what we'd like. I did want to address the point of alternative options. When we were looking to purchase the property, we did look at two potential options for the boat lift. And this is, of course, in the option period prior to purchase. Once we met with our dock contractor, the indicator from the contractor was the option that we are pursuing would be around $35,000. The option that was also proposed would be about $120,000. We would not only have to demolish a one-year-old dock, which was built in the exact footprint of the dock that had been there for decades. We'd also then only result in moving the outermost projection of the dock approximately 6 feet to the right. And so spending an extra, multiple times the cost of the most reasonable and appropriate lift was, in my opinion, both environmental and economic waste, and did not result in a significant variation to move more than 6 feet. Again, I've seen no fact evidence presented that installing a boat lift on the Intercoastal Waterway on the waterfront in Florida is going to reduce a neighboring property's value. There's been no evidence presented to that effect. I'm not sure how to address this second party that testified. There was some testimony as to precedent. Again, 56 of 80 lots already have boat lifts, including lots that are lifts that actually do encroach upon other properties, which ours does not. That was simply false. And again, I just don't really know how to address threats by others. That's not relevant to this case at all. And again, this ordinance has been discussed in several public hearings. It's been read several times. It's been debated and has passed by majority and on the recommendation of city staff and city attorney, and is also consistent with all of the other cities up and down this coast. And so to try and assert that your impartial and fact-based rulings in these hearings is somehow going to set a precedent is simply untrue. I don't know how to address that any other way. Again, this lift does not encroach upon the neighboring property. It is completely within our property, and that's all I have.
All right, thank you. Ms. Gish, anything you'd like to tell me while you're up here?
I think I'll just restate that these are not self-imposed hardships, that this is what we have acquired with purchasing of the land. So it is not, as one of the previous commenters had made, that this is certainly not a self-imposed, self-created hardship, and we are experiencing quite a bit of hardship not having a lift and experiencing that personal property, the damage to our personal property that we're not able to control. I think that's all I wanted to say. Everything else is in the application, which I know you've had a chance to read. So thank you very much for your opportunity to look over that and for your consideration for today and all of the work that the staff did.
Thank you. Mr. Trask, anything else?
No, sir.
All right, based upon the application submitted, the staff report, and the other testimony provided, I'm going to go ahead and approve the variance as submitted. Mr. and Mrs. Gish, I'll send that order to you at 850 Bay Point Drive.
Thank you, sir.
Okay, thank you. All right, that concludes the hearing on variance 2022-07, 850 Bay Point Drive. I understand we're going to move into the code enforcement portion of the hearing now, is that correct? All right, we've been at it for about an hour and 35 minutes. Do we want to take a break for 5 minutes? Do we need to take a technical break to switch over and everything like that, or we want to take a 5-minute break just
If we could, to make sure that the Zoom is up and ready.
All right, we will
Okay.
be in recess until 3:40 p.m. And again, we're going to move, variance is done, so if you're here for a variance, that's all done now. We're going to move into code enforcement. Mr. Trask, are we ready to reconvene and start the code enforcement agenda?
Yes, thank you.
All right, everyone, welcome to the City of Madeira Beach Code Enforcement Hearing. Again, my name is Bart Valdez. I'm the Special Magistrate appointed to hear today's cases. I'm a practicing attorney and have been a member of the Florida Bar for over 20 years. I've been appointed to this position in accordance and with the authority set forth in Chapter 162 Florida statutes. It is my role to fairly and objectively review the matters presented. As such, I would like to advise you of certain matters related to today's proceedings. Today's matters will be heard in the order that they appear on the agenda. Every effort will be made to hear all persons having relevant evidence, argument, or comments to offer related to the specific case that is being heard. If you wish to speak today, then in a few minutes you will need to be sworn in by the city attorney. In all cases, the city has the burden of proof. The city will present its case first. The respondent or property owner or representative of the property owner then will be given the opportunity to refute the city's allegations. Formal rules of evidence do not apply to this proceeding. However, I will exert every effort to ensure that fundamental fairness is afforded to all parties. After hearing all relevant evidence, I will issue an order. The order will be reduced to writing, and you will be provided with a copy by mail. Therefore, please make sure that we have your current address. Additionally, you are advised that I do not have the authority to grant you a variance, permit, or special exception of any kind during this hearing. My role is solely to determine whether a city code has been violated and to provide you a reasonable time to correct the violation by whatever means is available to you. Please be advised that you may be subject to a fine and a lien may be recorded on your property if the violation is not corrected by the compliance deadline. If you wish to present any information to me today, it is necessary that you swear or affirm that you will tell the truth. Therefore, in just a moment, the city attorney will swear in any witnesses. If you're appearing at this hearing virtually and you want to say anything to me today, you also need to swear or affirm that you're going to tell the truth. So anyone who's appearing virtually, you're going to need to raise your right hand and be sworn in just like those who are here in chambers. With that, Mr. Trask, can you please go ahead and swear everybody in?
Yes, anyone that's going to speak, you can stand up, raise your right hand. Ms. Suzan, you're on the phone. I also need you to acknowledge that you're listening. Do you swear that the testimony you're about to give is going to be the truth, the whole truth, and nothing but the truth? Ms. Suzan?
Yes.
Okay, thank you.
All right, again, the first case we have is case number 2020.1296 for the property located at 14033 East Parsley Drive. Is the city ready to proceed?
Yes, we are.
Go ahead, Mr. Trask.
As a matter of housekeeping, we have a request for continuance of this hearing. Ms. Souza is on the telephone or on Zoom. I can see someone just came in. They are asking, or she is asking for the continuance, and I think we should probably deal with that before we move forward with the hearing.
All right, ma'am, can you give me your full name, please?
Yes, hi, my name is Lori. Can you hear me?
I can.
Okay, my name is Lori Souza, and I am the power of attorney for Mr. Brian Murray.
All right, and ma'am, I understand you want me to not go forward, you want me to continue this hearing to when? The next available hearing time?
Pardon my lack of preparation or written preparation. I'm just receiving the violation, the notice of hearing today, and I'm unaware of any other documents besides this notice of hearing. However, since I am here logged in at this moment, I would like to hear what the city attorney has to say, if there's anything additional to this notice of hearing. And then also I would like to provide history and our plan of correction, if we could do all of that at this moment. And then if there are additional needs, we could continue in December when I will be there in person.
Mr. Trask, how would you propose to move forward?
Yeah, I'm not interested at all in hearing this case twice. I'd like to know the basis for the request for continuance and either grant it up or down, not have me present my case and then have her have a month to decide how she's going to respond to it.
May I speak?
Yeah, go ahead, Ms. Souza.
Is the case that you're presenting the two violations that I have that I'm looking at, or is there more documents that I would need to review? Because right now I have a document that's 3 pages. That's a notice of hearing that includes the 2 violations. That's all I have.
That is correct, ma'am. The agenda packet as it relates to this property is located on pages 100 through 130 of the agenda. I don't know if you have that electronically available to you or not, but if you click on the link.
No, I don't. I do not.
What
No.
I can tell you, ma'am, and this is based solely on the documents that were provided to me, is that the city's allegations are that there is some sort of structure on the property. It looks to me to be some sort of residential property, and it's unfit for human habitation. It appears that there are holes literally in the roof, in the ceiling. There's parts of the ceiling that are collapsing. There's parts of the wall that are coming down and whatnot. That's the nature of the violation based upon what I have here. Ma'am, I'm not unsympathetic to continuing these types of matters. However, I am concerned in this particular instance because we're dealing with a structure that the city has determined to be unfit for human occupation, meaning it concerns things that are health and safety type of
Yes.
issues. And I also note that, at least according to what I'm seeing, this has been, a placard was placed on the property back in January of 2021, and the
Correct.
notices that I have received are relatively recent, that this property remains, at least it's, as of September 21st, 2022, the pictures indicate that it may still be an issue. So I need to understand what the basis is for your continuance and what good cause exists as to why I should continue this hearing.
Well, I think what's important then, if we're going to continue forward, then we'll go in the order that you had requested previous, where the city attorney would present the case, and then I can respond properly.
Okay, I'm going to go ahead and deny the motion to continue at this point in time. We're going to go ahead and go forward today. Mr. Trask, go ahead and you may call your first witness.
I would call Holden Pinkard as the city's first witness in this case. Mr. Pinkard, what is your job responsibilities here at the city of Madeira Beach?
One of my tasks is issuing building code violations.
Are you familiar with the property located at 14033 East Parsley Drive?
Yes.
Okay. Who's the owner of that property?
Mr. Brian Murray,
And how do you know that?
the Pinellas County property appraiser and the Pinellas County tax collector.
If you could look at pages 100 through 102 in the packet, and tell me whether or not that is a printout from the property appraiser's office that you've produced.
Yes.
Okay, and also if you could turn to page 103 and 104, is that a printout from the tax collector's office reflecting Mr. Murray as the owner of the property?
Yes.
Okay. This property located at 14033 East Parsley Drive, when did it first come to your attention that there was a violation on the property?
It was back in January of '21.
Okay, and was this a proactive case or was this a complaint received?
I think I'm going to direct that to our building official, Frank.
Okay, hold on a second. He can answer questions later. If you don't know the answer to the question, just tell me you don't know the answer to the question.
I'm not sure.
Okay. So when this case came to you, whether it's proactive or reactive, can you tell me what the violation at the property was at that time in 2021?
It's section 1491, declaration of unfit structure, and section 14-70, general maintenance, specifically the sections that reference the roof, the supporting structural members, and the walls and ceilings.
Okay. Did you go to the property to determine whether or not these violations existed, or was that someone else on city staff did that?
Someone else in city staff.
Okay, if you could take a look at page 105 of the packet, starting at 105 and going through, it looks like. page 116, if you could go through each one of those pages and explain to the special magistrate what these documents are.
Sure. So page 107? 105. 105 is the courtesy notice that was sent, continued on page 106.
And this courtesy notice that was sent, where was it sent?
This was sent to 10953 70th Avenue, unit number 3 in Seminole, Florida.
Okay, why was it sent to that address versus the address listed by the tax collector?
I was given that address by one of our deputies who knew where Mr. Murray was living.
Okay, so Mr. Murray was not living at the residence at the time when this case started, correct?
Correct.
Okay. And so when the courtesy notice was sent, and the two violations that were noticed in the courtesy violation, did it give the property owner a period of time in which to come into compliance?
Yes.
Okay, and what date was that?
September 21st, 2022.
Okay, is the property into compliance as of now?
No.
Okay. If you could then keep going through those pages and explain what is reflected in the pages, starting at page 107.
Sure. 107 is the picture there, the front door, that's a picture of the front door as you walk in. And the debris from the ceiling looks to have been existing. There's no picture of the debris, but it has never moved since it's fallen down.
Okay?
Picture 108 is the back of the house, and you can see the sky coming through the roof there. And I have a picture with more detail, but you can see the trusses and the termite damage.
All right, if you could go to 109.
And 109, this is the hallway, and that's another hole in the roof, or I'm sorry, ceiling. And then picture 110 is a picture of the unfit placard that was posted on the property.
Okay, it's dated January 14, 2021. Is that the date that it was attached to the property?
Yes.
Okay. All right, if you could continue on then. Once the courtesy notice was sent out, it was not in compliance within the time period prescribed that you had mentioned. Did you issue this notice of code violation then listed on page 111?
Yes.
Okay. And is it the same code sections as the courtesy notice?
Yes.
Okay. And if you could go through the pictures then following that, starting at page 113. Look, some of them look to be the same.
Right, these are the same pictures.
Was this letter sent by regular mail and certified mail?
Yes.
And where was this notice of code violation sent?
This was sent to the 10953 70th Avenue, unit number 3, and that's Seminole, Florida.
Did you get a response from either the courtesy letter or the notice of code violation?
I did receive a call from Mr. Murray, and I did, I think shortly after, receive a call from Miss Lori.
Souza? Mm-hmm. You need to respond audibly to get it on the tape?
Yes.
Okay. All right. And when you spoke to Mr. Murray, did he tell you what was happening with the property, whether he was going to bring it into compliance or not?
He's aware of the current condition of the house.
He didn't tell you if he was going to bring it into compliance then?
No.
Okay. Then on pages 117 and 118 of the packet reflects the green cards, and it looks like the green cards were signed by Mr. Murray on page 118?
Yes.
Okay. Page 119, it's the same placard placed on the property?
Right, I believe these are the pictures that are in the letter. They're just the separate pictures.
All right, if you could go through each one of them then. Starting at page 112. Can't even read that. 120?
So 120 is another, just a picture of the unfit placard that was posted in January 14th, 2021. The next picture, again, is showing the front door area or living space with the ceiling or drywall removed or have collapsed. And a close-up picture, the next picture is the back of the house, and you can see clearly the sky and termite damage.
Okay, thank you. Then Did you, when you set this case for hearing, the special magistrate hearing, did you issue an affidavit of service, and is that reflected on page 122 of the packet, and 123?
Yes,
That reflects then that you mailed a copy of the notice of hearing for today's hearing via first-class mail by return receipt requested mail. You posted the property, and you also posted the notice of hearing here at the city?
yes.
Okay. Okay, and then if you could turn then to page 124, is this the actual statement of violation and request for hearing?
Yes,
And then the notice of hearing at 126 through 128, is that correct?
correct.
All right, and on page 129, it shows the front of the green card letter, but it does not show any green cards actually being sent. Do you have the back page of that, or the green cards reflecting a receipt of the notice?
This is the mailing of the regular and certified mail of the affidavit of service, statement of violation, and notice of hearing. They're all included in those envelopes, but I have the back, the green card on the back.
Okay. And then the last item is a photograph. Can you explain what is in the photograph?
That's a posting of all three notices, or the affidavit of service, notice of hearing, and statement of violation at the property.
Okay. So as of today, the property is still in violation of those two code sections?
Correct.
Okay. Have you received any other information from the property owner or Ms. Souza as the power of attorney as to when the property is going to be brought into compliance?
I have spoken with Mr. Murray and Ms. Souza, and I haven't heard anything about a certain day of when the property will be in compliance.
Okay. All right. I don't have any other questions for Mr. Pinkert. I would tender into evidence pages 100 through 130 as city's exhibit number 1.
All right, I'll go ahead and accept into evidence as exhibit number 1, pages 100 through 130 of the exhibit packet. I'll also mark as exhibit number 2 the email from Ms. Souza, the email exchange between Ms. Souza and Mr. Pinkard regarding her appearance at the hearing and the motion to continue, or what was a request to continue, shall we say. Ms. Souza, are you there?
I am here. Can you hear me?
I can. Ms. Souza, this is your opportunity as the representative of the respondent, the property owner. Do you want to ask any questions of Mr. Pinkard based on his testimony? I'm going to give you a full and complete opportunity to tell me anything you want to tell me. However, this is the opportunity you have to ask questions based solely on what Mr. Pinkard testified to. Do you want to ask any questions of Mr. Pinkard?
Sure. Holden, are you aware of Tropical Storm Ida that occurred on November 11th, 2020?
Yes.
Are you aware of the damage on Parsley Drive to most of the homes in the neighborhood from that storm?
Yes.
Okay. And then also, perhaps you know how many homes were affected that became uninhabitable due to not only the flood, but also from the wind damage?
I'm going to object as to the testimony and questions relative to other properties. It is not part of this particular case.
I'm going to sustain that objection.
Okay.
Ma'am, please move on to your next question.
Okay. I actually have a summary statement as far as questions. Were you,
And again, ma'am,
because
while
of
you're...
the damage of
Ma'am,
tropical storm?
Ma'am, Ms. Souza, hold on. I'm going to give you a chance to tell me whatever it is you want to tell me. You can talk to me about hurricanes and damage and anything you want. Again, this portion of the hearing is just for you to ask questions of Mr. Pinkard. And you don't have to create questions if you don't have any, but if you have some questions based on what he testified to, you can ask those questions of him. But you will have a full opportunity to present to me whatever you want to present to me.
Okay. Mr. Pinkard, were you aware of the conversation that I had with Frank DeSantis in summer of 2021 when I had made it known that I am the Brian Murray's power of attorney and that I am to be receiving, I will be the point of contact for this matter?
Yes.
And that I would be handling this situation on Brian Murray's behalf? And were you aware of my address in which to send the notice of hearing to?
No, I remember seeing that you were the power of attorney for permitting.
Okay, so, and do you have a copy of the power of attorney that was submitted to the city stating the full authority, my full authority on behalf of this matter?
We have a copy, yes.
Okay. And were you aware, do you recall the conversation we had last week about the insurance funds and our willingness to comply with the city to take care of this?
Our conversation, yes, I remember.
Okay, and I'm just curious, I know you had omitted that in the question with the city attorney. Is there a reason? When he asked you if you were aware that we were willing to come in compliance and you said to him, no, you weren't aware.
The last that we spoke, I believe that the way to come into compliance was to do work on the property, and I don't know if that's something that's possible.
So we have an open flood insurance, and the open flood insurance I had mentioned to you, which only is 13%, and we also have an appraisal, and I believe that is the reason. What's your reason that the work, you're stating that the work cannot be done on the home?
That's not what I said, and I think that would best be answered by someone in planning and zoning, because it would be a FEMA question.
Okay. So are you aware that Brian Murray is a disabled vet and needs the needed the assistance of additional people to be able to come into compliance with this situation?
I'm aware that he needed help.
Okay. Are you aware that Brian Murray is a 74-year-old man and a disabled vet who was boarded out of his house in January of 2021, only 2 months after Hurricane Ida?
Yes.
Are you aware that the city took the electrical meter off of his house, and the city also took the water meter off of his house and boarded up his house so he cannot do any work to the house?
Yes.
Are you aware that we are in need of the city's cooperation in order to remedy these non-compliance factors?
Yes.
Thank you. That's all.
Mr. Trask, anything else of Mr. Pinkard?
Nothing else for Mr. Pinkard. I do have another witness, though.
All right, go ahead and call your next witness.
Would call Mr. DeSantis as a witness. Mr. DeSantis, if you could tell us what your occupation is and your job responsibilities here at the City of Madeira Beach.
Yes, I am the building official for the City of Madeira Beach, and my responsibilities are to oversee the permitting building department.
Thank you. Are you familiar with this property we're talking about today?
Yes, sir.
Okay. Were you the person that issued the unfit for human occupancy placard that was placed on the property at 14033 East Parsley?
Yes, sir.
Okay. Can you briefly explain the reason why that placard was put on that property?
Yes, sir. Briefly, I was there the day before on the 13th, and I talked to Mr. Murray on the 13th about relocating him. He had several different folks in the community trying to help him relocate. He knew he had to relocate at the time. So we agreed on the 13th that he was going to relocate on the following day. He wanted a day to get his personal stuff together. So anyway, on the 14th, when I was out there with the deputies, I talked to Mr. Murray at the time, and we were in the process of helping him relocate to a different place. I don't know if he had an apartment or something, was rented something. Anyway, we were in the process of relocating him somewhere else, a safer location. And I went through the building on the 13th, that's when these pictures were taken, and there was excessive damage in the building. And I don't believe it was the hurricane, I believe it's extensive termite damage, as you can see by the rafters. There's not only excessive termite damage, but there were several holes in the ceiling throughout the building. As Mr. Pinker said earlier, a lot of the ceiling plaster was on the coffee tables, on the sofa, was never touched, moved, even on the bed in both bedrooms. The kitchen was completely out of place. As far as pulling the meter, we had the meter pulled after we issued the stop or the unfit. The water was controlled by the county, not the city. And I think that's about it.
Okay, so when was the first time that you were actually became aware of the property being in violation of the city code sections that were cited? Was it the 13th of January?
It would have been just before the 13th. I was talking to both deputies at the time who were involved in trying to relocate Mr. Murray, along with several other folks in the community.
Okay. So with regard to repairing this home, is it possible to repair it, or does it need to be demolished?
It's, unfortunately, it falls under FEMA. The 50% rule with FEMA because of the excessive damage throughout, whether it's issued or whether it was by hurricane or whether it was normal. Anyway, it's above the 50% value. I've had this discussion with the planning and zoning folks, and they concur. So it doesn't matter what happens, you can't fix the building. It's past the 50% value.
Okay, so it needs to be demolished then?
Yes, sir.
Okay. All right, have you had any conversations with Mr. Murray or Ms. Souza about rehabbing the property?
I did talk to Mr. Murray the 13th, the day before, about rehabbing the property, and he agreed that the property was in bad shape, and I tried to explain to him about the value of the property and how it complies under FEMA. And he understood what I was saying to him, but nothing ever came from that.
Okay, and did you speak to Ms. Souza about the property itself?
We met, I can't exactly tell you the date, but we met in a conference room here at City Hall with the city manager discussing the situation after she took power of attorney. We all sat down in the conference room and had the same discussion.
Okay. And when was that?
I'm sorry, I don't know. I couldn't give you a date on that.
Well, the placard was placed on the home on January 14, 2021. That's almost 2 years ago. So was it in 2021, do you think, or was it this year in 2022?
I would say it was 2021.
Okay. And with regard to the FEMA rules, when you say it can't be rehab, that needs to be compliant with FEMA rules, does that mean then that the property has to meet current code? In addition to that, it has to be at a certain elevation?
Per FEMA, planning and zoning can answer that better, but per FEMA, it's got to meet the 50% rule and the city ordinances, and it doesn't.
Okay. All right. I don't have any other questions of Mr. DeSantis at this time.
Ms. Souza, are you still there?
I'm here.
All right, you just heard Mr. DeSantis testify. This is your opportunity to ask him any questions you want to ask him specifically about the matters that he testified to. Do you want to ask Mr. DeSantis any questions?
Yes, absolutely. Frank, do you recall that Brian Murray stating that he did not have anywhere else to go in January of 2021 after Hurricane Ida in November of 2020?
No, I don't. He's had multiple places to go, according to the deputies that were working with him.
Okay. And do you recall our conversation that I was able to provide him with temporary housing in April of 2021?
Yes, was that the conference room meeting?
That was when we were at my property, because my property also came under the same umbrella of not meeting the 50% rule per FEMA. And I actually had to work with you in regards to my property also not meeting that rule. So because you and I were able to accomplish that, and I was able to get my property in compliance and get the work done, this is one reason why Brian trusts that I can work with you on his property and helping to complete this journey just as I did mine. But are you aware that he stayed at the Holiday Inn for 1 year in temporary housing so that we could comply with the violation, the first violation you put out, which was the property's not inhabitable? Or it's, yeah, we complied with violation number 1, which was that nobody can live, with the picture that you showed, that Holden showed saying nobody can live here. We complied with that in April of 2021 when we provided temporary housing for Brian Murray. Do you recall?
No, I wasn't involved in the temporary housing.
Okay, do you recall the meeting in July of 2021 with Bob McDaniels, yourself, and Megan, and myself?
And was that the
Myself.
Was that the conference room?
That was in the conference room, yes.
Yes, I remember that.
And the plan of action in order to remedy violation number 1 was to make sure that Brian Murray had a place to live, because we all knew the property was not to be lived in, correct?
Sure, yes.
Yeah, so at that time, I had shared with you that I did indeed find a place for Brian Murray to live, that he would no longer have to live in his backyard or in his truck because his home was boarded up. Do you recall that?
I don't recall those words, no.
Okay. Do you recall Brian Murray having to live in his truck in his backyard because you had boarded his house up?
No, I don't.
Okay. Do you recall that the notice was not put on Brian Murray's house until you discovered that he was living in his backyard?
Nope, that's not true.
Okay. So do you recall the deputies coming to your office and letting you know that Brian Murray is not safe living in his backyard or his truck because his home was boarded up?
No, they told me it was not safe living in that house, and that's why I took a tour through the house.
Okay. Okay. Possibly the deputies could testify to what they did tell you in the office, where Brian Murray was living and how he had to live because his house was boarded up. Regardless of that, do you recall the meeting when we came up with a plan of action in July of 2021 in order to remedy violation, the first violation, which we remedied by providing Brian Murray temporary housing? And that was remedied during that meeting. He was already living in temporary housing in July of 2021.
I don't remember that.
Okay. Perhaps Megan took, I believe she took notes during that meeting.
Yes.
The second violation was our main concern, in which you, Bob McDaniels, and myself came up with a plan of correction. And the plan of correction was for me to order an appraisal. Do you remember that discussion?
Yes, I remember that.
Okay, and then also for me to gain access into the home so that we could have the insurance company come into the home and determine the amount of damage. Do you
Yes.
recall that?
Yes.
Do you recall that the home you had to assist us to unboard the home to allow anybody into the home?
Yes.
Do you recall that the insurance that we were efficient in getting, we had a 2-hour window where we could get in the home, and we were efficient in ordering an appraisal. We were efficient in ordering a contractor. We were efficient in ordering a termite inspector, and we were efficient in ordering the insurance adjuster to come in that 2-hour window. Do you remember that?
That was per the city manager, and yes, I do.
Okay. And do you recall that the city came and boarded the house right up quickly after that? And we made sure we took care of all of that within 2 hours in July of 2021.
Yes.
Okay. And do you recall the results of the appraisal, which was $300,000, was sent to your office in August of 2021?
I'm not familiar with that. That would have to be a planning and zoning question.
It happened within a month after our plan of correction when we verbally had a meeting, and Bob McDaniels was very supportive and let's get this done quickly. So I quickly sent the appraisal within 1 month to your office, and I copied all the emails so that you had a copy of the appraisal, which proved that it did not fall under the 50-50 FEMA rule, just like mine, just like my property didn't.
I'm not familiar with that. Again, that's a planning and zoning question.
Okay, so the appraisal was sent to your office. It was received in August 2021. And the insurance claim was completed, and we do have funds for the repairs. Are you aware of that?
No, I'm not.
Okay, we've been sitting on the funds. We've been waiting for a reply from the city for over 1 year now. And this is what Brian Murray gets, is a notice of hearing and demolishing his property. Okay, are you aware that Brian is no longer in temporary housing, that I was able to secure him an apartment with a year-long lease?
No, ma'am.
Okay. Okay, are you aware of the address that this notice of hearing was sent to?
Yes.
Okay, the address, and what was your thought on what that address was?
I was not involved in that, so I couldn't answer that question.
And as far as the plan of correction that you, Bob McDaniels, and I spoke about in July of 2021, what have you done in regards to help us make sure we remedy the non-compliance issue, to help us to onboard the house, to put the electrical meter back on, and to get the water meter back on so that we can comply and we can get the work done in an expedient manner?
Again, I believe planning and zoning was waiting for an appraisal to be reviewed and approved.
Okay, so planning and zoning had the appraisal since August of 2021 and have not, no one has contacted me. No, everybody knows I'm the point of contact for this matter. I have not received any contact. And would it be you that would contact me on this or review the appraisal?
No, ma'am, that's planning and zoning. Everything that involves FEMA goes through planning and zoning, not the building department.
Okay, and which department do you work for?
The building department?
Is the building department associated with planning and zoning?
Sure, we work side by side.
You work side by side, so you don't communicate. And so when I got my appraisal for my property and I had to discuss that with you, was that a different scenario than Brian's?
No, yours would have still went through planning and zoning for review and approval, whether you discussed it with me or not.
Okay, and but you were my point of contact on that appraisal. You were the point of contact on that appraisal for my property. Is there a reason why you're not the point of contact for the appraisal on Brian's property?
Are you referring to the point of contact, the building department?
I'm referring to the person who's responsible for reviewing the appraisal and approving us to do the work on the property.
That's not me, that's planning and zoning. I don't review appraisals.
Do you see that there'd be any problem knowing that we have an appraisal, knowing that it's only 13%, the insurance money that we have is only 13% of the appraisal? Do you have any problem with providing Brian Murray and myself a permit to get this work done expediently to meet compliance?
As long as it was approved by planning and zoning and comes to me, I don't have a problem with it.
Are you concerned with the welfare of and the health and welfare of Mr. Brian Murray, disabled vet who's now 74 years old and has been displaced in his home for 2 years?
Objection, it's irrelevant.
I'm going to
It's very relevant. This is a human matter.
Yeah, Ms. Souza,
He's
again,
boarded out of his house, has no electricity.
Ms. Souza, you're going to have an opportunity to present to me everything you want to present. This is just cross-examination
Okay.
in regard to the testimony
Okay.
that Mr. DeSantis provided, and he didn't testify on direct about those things. So I'm going to sustain that objection. You can move on to your next question. And again, I remind you, you're going to have a full and complete opportunity to tell me and share with me anything you want to. But if you want to continue to ask questions of
Okay.
Mr. DeSantis, you can do so.
I'm done for now. Thank you.
All right. Mr. Trask, is there any follow-up you want with Mr. DeSantis?
I don't have any additional questions for Mr. DeSantis.
All right. Do you have another witness you'd like to call?
Yes, I'd like to call Jenny Rowan.
All right. Go ahead.
Ms. Rowan, if you could state your name and your occupation and your job responsibilities here at the City of Madeira Beach.
Yes, my name is Jenny Rowan. I am the Certified Floodplain Manager, and I am a Senior Planner in the Planning and Zoning Department.
Are you familiar with this property, 1403 East Parsley Drive?
I am. When this code compliance letter came into the unfit for human occupancy, I was not working at the city at that time, so I know that Linda Portal has also been involved in this case. So I might not be able to answer all the questions, but I do know a little bit of the case.
Okay. Mr. DeSantis had testified earlier today relative to the FEMA 50% rule. If you can explain that rule and how does it apply to this property that is owned by Mr. Murray?
Yes, so if a property is not up to current floodplain regulations, we have to look at the FEMA 50% rule, which is you can only improve your property up to 50% of the depreciated value of the structure.
Okay. Ms. Souza has been asking questions relative to an appraisal that she says was provided to the city. Are you aware of the city receiving that appraisal in the planning department?
I have an email from August 5th of 2021. It appears that both Linda Portal, which is the Community Development Director, she's also the Certified Floodplain Manager. It says, Linda and I both agree we cannot accept the appraisal. The appraisal is a restricted appraisal report, which contains minimal detail or content and can legally only be relied upon by the client, not any other party. And on the Pinellas County Property Appraiser's website, which is what we were looking at before receiving an appraisal, it appears the FEMA 50% number is $15,700.
Okay. And when you say you're looking at the Pinellas County Property Appraiser's website, the one that's attached in the packet at page 100 reflects an assessed value of $97,998. Is that the value you were talking about as a starting point? I'm just trying to figure, if you can explain to me how you came to the $15,000 value that the house can be repaired to.
So on the Pinellas County Property Appraiser's website, if you look up the property on the top right corner, there's a FEMA link that will pop up what's on the screen right now. They adjust this, I don't know how frequently, but they do adjust it. So as of today, the FEMA 50% value is $15,700.
Okay, so this was not a value that you determined. This is a value that the Pinellas County Property Appraiser's Office determined.
That is correct.
Okay. So in theory, then, they cannot put any more money into the repair of this house greater than $15,700?
That is correct at this time. They could have the appraisal redone, but the appraisal that Linda Portal, the Community Development Director, and myself reviewed we could not accept that appraisal. It would have to have the depreciated value of the structure.
Have you and someone in the planning department or the building official made a determination that it's going to require more than $15,700 worth of repairs?
Usually we work with the building department on that. I do not remember going through the property and assessing how much value that repairing the structure would come to.
Okay. I don't think I have any other questions for you, Ms. Rowan. Thank you very much.
Ms. Souza, do you have any questions for Ms. Rowan?
Yes, absolutely. Hi, Ms. Rowan. So Ms. Rowan, are you aware of the discrepancy between the Pinellas County appraised value and the actual market values in that neighborhood?
I know that usually appraisal, when you get a third-party appraisal, it's usually quite higher, and we do accept third-party appraisals.
Okay, and so you had mentioned you did not accept this appraisal. Could you specify the reason?
I don't have the appraisal in front of me, but I do have an email from August the 5th of 2021 that says that the appraisal was a restricted appraisal report, and we are not allowed to accept the restricted appraisal reports. We have to see every detail on what's valued in the appraisal and having the depreciated cost of the structure itself. So we could accept another appraisal.
Are you aware that I submitted the same appraisal for my property and it was accepted?
No, I am not. Or I do not recall that. I may have not been.
Okay, and that's what I had to. Are you aware that I live across the street from Brian Murray and I had to go through the same process with the city?
Objection relevance.
It's very relevant because it's the same appraiser and it's the same appraisal.
Ma'am, I don't have either appraisal in front of me, so I'm going to sustain the objection. But again, if you have documents you
Okay.
want to show me during your presentation, I'll consider at this point in time. But it's sustained, so go on to your
And-
next question.
Would you allow me to submit documentations in regards to the insurance claim as well? I don't have any of that today. I'm
Well-
actually not in.
Ms. Souza, let's do this. Let's
Okay.
stay on the part of the hearing that we're on right now, which is the cross-examination of Ms. Rowan. Do you have any further questions
Thank
for
you.
her?
Yes, Ms. Rowan, when you received the appraisal in August of 2021, in order for homeowner Brian Murray and myself as his power of attorney to comply with the violation, what is your normal process in the city to inform us of your denial of that appraisal?
We usually send an email to the applicant. I received, from this email that I have in front of me, it looks like the building department provided us with the appraisal and we responded to the building department and the city manager on that appraisal.
And whose responsibility is it to communicate with the homeowner that you did not accept that appraisal?
It's either the planning department or the building department. Usually it's the planning department if we have an application. I don't recall seeing an application, and again, this was August of 2021, so I don't really remember seeing an application, but I do have this email.
So, and which department do you work for?
I work for the planning department.
The planning department. And so who is the responsible person who would communicate with the homeowner about the denial of you not approving the appraisal?
Sometimes it comes from the planner who is reviewing the application. Other times it comes from our community development and planning department assistant.
So who is the planner reviewing this particular file who would be responsible for providing the homeowner with this information?
Like I said, this came in before I started working with the city. So I know that, I believe that Linda Portal, the community development director, was looking at this application before I started working for the city. So it may have been her, it may have been me. It's been over a year, so I can't tell you a definite answer.
And are you aware that the appraisers, the Pinellas County Appraiser's Office values are significantly lower than the market values of the properties?
Yes, generally they are. We do accept third-party appraisals to determine that 50%.
And is the city willing to take a look at this appraisal for $300,000 and inform the homeowner of why, which would be me, I'm the power of attorney, why that this appraiser or appraisal is denied
Yes, I have
in detail.
We can look at the appraisal again and we can go over that in detail with you.
And would you have any problem with reviewing the appraisal and possibly accepting it as it was accepted in the past for other properties?
It determines on what's in the appraisal and how the appraisal looks. I do not have the appraisal in front of me, and I don't recall exactly what was in the appraisal. But I have no issues with reviewing the appraisal again and going over that in detail with you.
And are you aware that we have an open insurance claim and the amount of damage and repairs are $40,000?
I do not know that.
That's all I have right now.
Mr. Trask, anything else for Ms. Rowan?
No, no redirect.
All right. Mr. Trask, are there any other witnesses you'd like to call?
No, sir.
Ms. Trask, I'll give you a time at the end to do any final closing or any additional argument.
Thank you.
All right, Ms. Souza, it is now this part of the hearing where I want to hear from you and like to hear anything you have to tell me. I don't have the ability to see anything I don't believe that you would pull up, but I'm certainly happy to listen to any argument you want to make. And if you want to call any witnesses on behalf of the property owner, you're free to do that as well.
Okay, thank you. And first of all, today was the first day I received a copy of the hearing notice, so I first of all apologize for not being fully prepared and providing any documents to give you. I certainly do have documents. I have been working on correcting and remedying the situation since I became Brian Murray's power of attorney and have made great progress for Brian Murray on Brian Murray's behalf since March of 2021. The first I'd like to just mention is in violation number 1, I ask that be removed from Brian Murray's record because the main reason for violation number 1 was that he was still living on the property and it was not safe for him to live on the property. Even after it was boarded up, he had to live in his backyard and his home. And so that's when the notice was posted on Brian Murray's home. That's when I came in and helped find Brian Murray housing, and we removed him from the premises, and he is in a safe space. He's living in an alternative housing until we get the repairs done. So I ask that the home no longer be boarded up so that we can actually start to remedy and get these repairs done. Let me just give you a little bit of history. Tropical Storm Ida occurred on November 11th, 2020. Not only did 14033 East Parsley become flooded, but most all homes on Parsley Drive became uninhabitable, looking at 2 feet, in excess of 2 feet of standing water and much wind damage. We had over 10 to 15 neighboring homes receive the same violations of the FEMA 50% rule by the city, including my own. And Brian Murray was, myself and many other homeowners were cognizant to understand the steps needing to be taken to file a flood claim. And however, Brian Murray being at the time, 72-year-old disabled vet, was unable to take the steps needed to remedy and return his home back to habitable condition. He refused to leave his home. He had nowhere to go. However, he did reach out and ask for help from the city and from the deputies. The response to Brian's Murray help from the city was that he continued to reside at home, but the response to that was the city coming and boarding up after they found out that he was still residing in his backyard and in his truck, boarded up his home, removing his electrical meter, removed his water meter, and Brian Murray had to now find where else to sleep. He finally asked me, his neighbor, to help him with remedying this process, as I was able to get an approved building permit from the city. He knew I had experience in property management and have been going through this also for 6 months with the city before I was able to get a building permit, which was 9 months after Tropical Storm Ida. It took me 9 months. To represent him, he asked me to be his power of attorney and submit all paperwork and documentation to the city on his behalf, that I would handle the situation for him because of my cognitive ability. And in the spring of 2021, I met with Frank DeSantis, Bob McDaniels in the summer of 2021 and discussed our plan of correction, as I had mentioned. We did come up with a plan of correction for remedying violation number 1, and that was removing Brian Murray from the premises, which we did. We found him alternative housing. So I asked that violation number 1 be removed. Number 2, plan of correction was to get an appraisal, allow the flood insurance to come in, get all of that taken care of. I have also been working with disabled vets organizations and including our neighboring Elks Club. We have several volunteer organizations that are willing to come in and help with our disabled vet who is displaced right now. Understanding also that we have worked efficiently, expediently to remedy these violations. However, without access to the home, with the home being boarded up, with no electrical meter so that we can have anybody start work, and with no water meter, we really need the help of the city to remedy these. And so our main concern, I do want to let you know, we have filed a flood claim. We did have a flood adjuster come out, determine the amount of damage, and the funds are waiting to be released until we have access to the home. So those funds are available to meet compliance. We do have veterans organizations, grants, and our neighboring Elks Club willing to help, and our neighbors are willing to help Brian into remedying the situation. Any documentation you need, supportive documentation you need, I would ask that I receive an email. I can send you documents with the flood claim, the adjuster, and the appraisal. I did, just so you know, as a community member, paid for that appraisal so that we could expediently make this happen. And we do have many other volunteers willing to help out with this as well. That's my statement right now, and I apologize, but I will have to be cutting this very quickly because I'm being called in the other into another project.
All right, Ms. Souza, if you can hang on as long as you, obviously I can't keep you here, but certainly would, you can leave whenever you want, but I'd like to give Mr. Trask the opportunity to ask you some questions about your testimony if he has any questions.
I do have a few questions.
Okay.
Ms. Souza, what is your background? What do you do for what is your occupation?
So my occupation is I'm a real estate instructor. I teach real estate agents and real estate brokers. I teach property management companies. I am a licensed real estate broker in California and Arizona. I am a property manager in the state of Florida and in the state of Arizona. I've been managing properties and multifamily properties, complexes since 1988. I have helped remedy many rehab projects for many clients who have asked me to come in and manage these projects. So in my experience is over 20 years running a real estate brokerage, solving problems in the real estate industry. And also right now I'm focusing mostly on teaching and coaching.
Are you a general contractor?
Not at this moment, no. I am working on that.
Have you ever been a general
I'm a
contractor?
property manager.
Have you ever been a general contractor?
No, I have not. I've always served as a property manager.
Okay. Back to your testimony about being expedient, what has Mr. Murray done, or what have you done to bring the property into compliance since the summer of 2021?
The summer of 2021, after we provided the appraisal to the city, we have just been waiting for the city to give us our next step because what we did was follow the plan of correction. And that was created in July of 2021 with Bob McDaniels, Frank DeSantis, and myself. I followed the plan of correction we came up with during that meeting. And so I have not received any, I have sent the documents to the city that were requested.
Okay, so if I'm to get this straight, then that you worked really hard through the spring and the summer of 2021 to work on this project, but since the summer of 2021, there's been no action taken to bring the property into compliance. Did I hear you correctly?
No action can be taken because the house is boarded up, the water meter, and there's no approval by the city for us to get started on working. We've had no approval.
Okay. When was the last time? Well, tell me, how many times between the summer of 2021 to the summer of 2022 did you reach out to the city to check on that permit or that application?
About 4 or 5 times.
Okay, and what did you do with regard to that? Was that an email or a phone call?
Several times I met the mayor this summer at the property, and we had a few conversations about the property. I also met with Frank DeSantis at the city. I've met with the deputies at the property. I've met with, there was another gentleman, he no longer works there. He was, I would call him Frank's sidekick. Pat, I can't recall his name. He no longer works there, but he was my point of contact.
All right. Have you or Mr. Murray hired a contractor?
At this point, the city has not given us any permission to do that.
So you've not contacted any contractor then to work on this project?
We have no access to the home, sir, so we cannot get, we need to get contractor quotes. That's where we are right now.
Okay, have you asked the city?
We need to have access to the home.
Did you ask the city for permission to have a general contractor walk through the property to give you an estimate to make the repairs?
Well, in following the plan, yes, I have, but in following the plan of action, our next step was to get an approval from the city because we do have a approval, a contractor that did go through during those 2 hours in July of 2021. However, as you know, prices have gone up. We do need to get an approved, an updated for the flood insurance to be released. We need an updated, statement from a contractor. So that needs to be updated because it hasn't taken so long.
Other than these discussions with the building official and with the mayor and with the city manager, has there ever been an application for a building permit filed with the city?
Yes,
Okay, and who filed that application for a building permit?
I did.
And did you do that on behalf of the property owner or a general contractor?
Yes,
Which-
on behalf of the property owner.
Okay. And when was that application filed?
I have record of that. I apologize. I don't have the dates where I am located right now. I do have that information. I do have the denial letter or the stamp that it was not approved.
Okay, so let me
I don't recall when that was.
All right, so if I'm understanding you correctly, a building permit application was filed and it was denied. Is that correct?
Correct.
And there's been no other building permit applications filed since that one was denied, correct?
No, because I need direction and help from the city. We want to get an approved permit on behalf of the property owner. I did mention that we do want to get a permit so that we can get things moving.
When was the
Get it
building permit application denied?
I'm sure the city has records of those dates, but it was in 2021.
All right, I have no other questions for Ms. Souza. Thank you.
All right, Ms. Souza, is there anything else you would like to present to me today before I open it up to public comment?
What I would like to do is just make it be known by the city that we wish to cooperate in remedying the second violation and complete the second violation and ask that a building permit request by the homeowner be approved, ask that we have the electricity and water returned to the home, and also the home is no longer boarded up. And knowing that Brian Murray is in a safe location and will not be returning to live in that property.
All right, thank you, ma'am.
Thank you.
All right, now we'll open it up for public comment. Let's start for people that are here in chambers. Is there anyone here in the chambers today that would like to talk on this specific code violation for the property at 14033 East Parsley Drive? Seeing none, is there anyone who's appearing at this hearing virtually today that would like to comment, any members of the public that would like to comment on the code violation at 14033 East Parsley Drive? All right, hearing none, we'll go ahead and close public comment. Mr. Trask, anything else?
Yes, I would just like to summarize briefly if I can. So I agree with Ms. Souza that Section 14-91 is in compliance as a result of Mr. Murray not residing in the property. As for Section 14-70, there's been significant evidence shown to you as a special magistrate that the property is still in a state of disrepair. It is in such a state of disrepair that the home is unfit for human habitation. It's been placarded, as you've heard. We're asking that you find the property in violation of Section 14-70 of the City Code, give the property owner 30 days in which to bring the property into compliance, and if not brought into compliance within that time frame, that the maximum fine of $250 a day be placed because of the state of disrepair of this house. And that's all I have.
Mr. Trask, and please feel free to, if you need to ask the city representatives any question, I just want to make sure I understand what in compliance means here, because I see plan of correction in the notice of violation. So can you clarify for me what the owner needs to do to bring this property into compliance?
Demolish the home.
Okay. All righty.
For $40,000.
All right. Based upon the evidence that was provided to me, I'm going to go ahead and, based upon the stipulation of the city, find that the property is in compliance in regard to 14-91. Based upon the preponderance of the evidence before me, I do find there's a violation of 14-70. The corrective action that the city has provided is that the property will need to be demolished within 30 days. There is a life safety, health, and wellness issue going on here. Based upon the sole evidence that's provided to me and the pictures that I reviewed, the home is in a state of severe disrepair. So I understand the city asking for 30 days, plus it's been in this condition since it apparently January of 2021. Ms. Souza, I would encourage you to reach out to the city staff and try to meet with them as soon as possible to address anything. I will, as I do in every case, I maintain jurisdiction over these cases in the event that you reach some sort of compromise or some sort of resolution with the city. If you need more time to come into compliance or something along those lines, then you can ask the city to notice it for another public hearing, and I'll consider whatever mitigating circumstances you'd like me to consider. But right now, I'm going to go ahead and find the property is in violation of 14-70, 30 days to comply. In the event that the home is not brought into compliance, which is demolishing the existing structure, then there'll be a $250 a day fine. So that concludes the hearing on case number 2020.1296. We'll move on to the next case on the agenda, which is case number 2022.3431 for the property located at 154th Avenue. Is the city ready to proceed?
Yes, we are.
Go ahead, Mr. Trask.
I would call Laura Robbie. Laura, if you could please state your occupation, your job responsibilities here at the City of Madeira Beach.
Yes, sir. My name is Laura Roby. I am the code enforcement officer here in the City of Madeira Beach. And I've been here for approximately 11 and a half months now.
Okay. Are you familiar with this next case, case number 2022.3431 for 154th Avenue?
Yes,
Okay. And is this a proactive case, or was this as a result of a complaint that the city received?
proactive.
Okay. Were you the one that determined that there was a violation on this particular property?
In actuality, no, I was not. I was the one that wrote all the letters and pursued it. Mr. DeSantis was the individual that actually noticed that violation.
Okay, well, let's start with the ownership of the property. Who is the owner of the property where the violation is occurring?
The owner of the property where the violation is occurring would be Mr. Frank, and please forgive me if I mispronounce the gentleman's last name, Cusamonto, I believe that's how you pronounce it.
Okay, well, this property was cited, and the notices went to Algean Shores Condominium.
Yes, sir.
Okay, and I'm asking you questions relative to where the fence is located in relation to the property. Is it in the common areas, or is it?
Yes, sir, it is.
Okay, and so that's the reason why Algean Shores Condominium has been cited with this violation?
Yes, sir.
Okay, so starting there, how did you determine who the owner of the common areas were of the property?
As you can see with the Pinellas County Property Appraiser.
Okay, so if you're looking at page 131 and 132 of the packet,
Yes, sir.
that is the printout from the Pinellas County Property Appraiser,
Yes, sir.
and it reflects that the property owner is Algean Shores Condo at 154th Avenue here in Madeira Beach?
Correct. Common elements, yes.
Okay. And was that followed up by, on page 133 of the packet, a printout from the tax collector?
Yes.
And does it provide the same property owner?
Yes.
Okay. Now, let's talk about the violation itself. When the violation first came to your attention, can you explain to the special magistrate what the violation was?
Yes, sir. The violation was brought to my attention by Mr. DeSantis that that particular location had a fence that was, obviously had not applied for a permit and was not in compliance with our city code.
So was it a new fence, or was it a fence that had been there for some time and just discovered?
It was a new fence.
Okay. Did you go out to the property to see whether or not that violation existed?
Yes, sir, I did.
Okay. And when you went out to the property, what did you find?
I found a brand-new fence on the property, and throughout the correspondence through the individuals who are responsible for it, this fence was put up without a permit, and it somewhat replaced an older fence that was there that was also in violation.
Okay, so when you found that there was this fence installed on the property with a permit, did you issue a courtesy notice of violation?
Yes, sir, I did.
Okay, and is that shown on page 134 and 135 of the packet?
Yes, sir, it is.
Okay. And what violation was the issue?
The location and height of fences in front yards.
Okay. And so did you cite the property owner with a violation of section 86-52?
Yes, sir. When required, whomever did the repairs or replacement of the fence did not get a permit, the required permit.
All right. And when you gave this courtesy notice, what was the date of that?
The date of this particular one was June 21st, 22.
Okay. And did you give the property owner some time to come into compliance?
Yes, sir, I did. On this particular notice, it was July 1st, 22.
Did it come into compliance by that date?
No, sir, it did not.
Okay. I'd like you to turn to page 136 of the packet, and there are some photographs that follow. If you could just go through those by page and explain to the special magistrate what we're looking at in each one of
Yes, sir.
these.
This is, the picture here that you're looking at is the location, the property, that's the actual address in front of the building itself that you're looking at. The building will be on to your right. The property, actually, the fence is on your left on that particular property. Right there, yes.
Okay, and what, before we move on from that, what is the height of that fence?
6 feet, I'm going with.
Okay. Does that mean that you didn't measure it specifically, but,
No, sir, I did not measure it specifically, no.
okay. Did you stand beside it?
Yes, sir, I did.
Okay, how tall are you?
I'm 5'5".
Was it above your head?
Yes, sir, it is.
Okay, thank you. All right, so the fence then on the picture that you showed us, and if you could go to the next photograph?
Yes, sir. Now, that is from the side profile of the fence from the driveway of the property.
Okay. All right, next I'd like you to turn to page 139 of the packet, the notice of code violation stated August 24th, 2022.
Yes, sir.
Did you issue this notice?
Yes, sir, I did.
And did you give the property owner some additional time to come into compliance with this notice?
Yes, sir, I did, September 5th, 2022.
Was he in compliance with the condo association in compliance by that date?
No, sir, they were not.
Okay. And did you issue then a notice of violation for the hearing for today?
Yes, sir, I did.
Okay. And if you could turn to that page. Which in my packet, it's statement of violation and notice of hearing. It's like page 162 or 152.
Yes, sir.
This is the notice that you provided?
Yes, sir, it is.
Okay, well, this notice or statement of violation has two code sections cited.
Yes, sir.
So in addition to the 8652, which required the permit, you also cited a different code section. What is that code section for?
That code section is the section for front yards and fences and hedges in the front yard, which is from our city code.
Okay, so that was section 110-447.
Yes, sir.
So this fence in the front yard can be no greater than 3 feet in height, even if it had a permit?
Correct. Yes,
Okay,
sir.
Okay. And this fence, we know, is over your height, so approximately 6 feet?
Yes, sir.
Okay. When you issued that statement of violation, did you also go ahead and do an affidavit of service on that?
Yes, sir, I did.
Okay. And is that reflected on page 150 of the packet?
Yes, sir.
All right, so did you send the notice by green card,
Yes, sir, I did. I sent a notice by green card.
by regular mail?
Yes, sir, by regular mail.
Did you post the property?
Yes, sir, I did post a property.
Okay, and did you also post the notice here at City Hall?
Yes, sir, I did.
Okay, and did you take a photograph of that?
Yes, sir, I did, which is that photo right there. Back up, right there. That's posting, that's the proper, that is the photo of the property being posted. right
Okay.
there.
So, once this notice went out, did the property owner take some action to bring the property into compliance?
Yes, sir. They did take action. They did actually have removed the fence panels were removed. However, the fence posts unfortunately are still there, which have to be removed. And also, they did not apply for a permit.
Okay, so as of today, no permit, fence panels are down, just the fence posts are up?
Yes, sir.
Okay,
At this time, yes.
okay. Have you had contact with the condo association or the property owner associated with that fence?
Yes, I originally, when this started back beginning of the year, I had contact with the property owner, and then subsequently last week I had contact with the association, And I was informed that they will be taking care of the situation and the fence, actual fence will be down. But when I arrived in this morning, I took photos this morning of the property, and as I have here, the fence panels are down, however, the posts are still up.
All right, if
And
you-
there is still no permit,
Okay,
after the fact permit.
if you could go to that page which reflects the fence posts, the photograph, do you have that there?
Yes, sir, I do. Would it be okay if I bring it over?
Oh, it's not on the.
No, I
it's
just
not
did
on the
that
grid.
today.
Okay.
Yes, sir.
All right, if you could then show that to the special magistrate, so he has that. Okay, thank you. So how much time do you think it would take to bring the property into compliance by taking those fence posts down?
A week.
Okay. Are they cemented into the ground?
I want to say yes.
Okay, all right. So you think a week would be sufficient enough time to be able to?
Yes, sir.
Posts out? But if they came in and pulled a building permit and lowered those posts down to 36 inches and otherwise complied with the code, a fence could be issued, or fence permit could be issued?
Yes.
Okay. All right, thank you. I have no other questions of Laura. I would
Alrighty.
tender into evidence, though, the packet, which is pages 131 through 158, in addition, the photograph that was just handed in.
All right, I'll go ahead and accept into evidence as exhibit number 1, pages 131 through 158 of the agenda packet. I'll also accept into evidence as exhibit number 2, additional photographs that were taken and provided during the course of the hearing today. Is there anyone here, is the owner here, anyone on behalf of the owner or respondent? Sir, what is your name?
Frank Cusimano, but I'm referred to in these papers as Jay.
All right,
That's
sir.
what I go by.
Frank, how do you spell your last name?
Cusimano.
Okay. Mr. Cusimano, I'm going to give you a chance to tell me whatever it is you want to tell me in just a moment. Do you have any questions you want to ask Ms. Roby?
Yeah, I do.
All right, go ahead.
Just let me get my. Okay, the notice that was given in January was the original notice. Is that correct? January 31st, 2022? I have it here.
Yes.
Okay.
Yes.
All right. Was there a mail, like, that has been noted on these other one notices, that a notice of the hearing was mailed certified, a notice of a copy of the attached notice of the hearing via first-class mail, and also being posted? Did all of that take place?
Yes, sir. I believe I answered that question, yes.
I beg to differ, because I was there, and no notice was sent to me. I have letters from the condo association president and the condo president and the condo association manager that they have not received any correspondence whatsoever. And I've got those signed letters here.
Yes, sir. If it's okay, I would like to present into another evidence here, because as the actual from March 15th of 2022, and I believe that would be your signature of the notice.
I would have to look at it. I really don't.
Well, sir, again, I'm going to give you the opportunity to present anything you want to present
Yeah.
to me today. The question that's really relevant to me today is whether you had notice of this particular hearing. And the fact that you showed up is indicator that you had evidence of notice for this hearing.
Correct.
But if you want to say that the city didn't work with you, why don't you save that until it's your
Okay,
part to tell
all
me
right.
whatever you want to tell me. But do you have any other questions for Ms. Roby
Yeah,
about just what she
absolutely.
testified to?
Absolutely. The latest notice that was sent out in, hold on, in September, which also stated that there was mail return receipt, first-class mail sent. There was a posting that did happen. Was there a certified letter, or for all of these? Actually, I'm asking for all of them. that
Oh,
was sent out.
absolutely. I will be more than happy to accommodate you. I have all the undeliverable letters since the beginning of this year, since, probably, was it January? that
I've not changed the
I've
addresses.
spoken, I'm sorry, is your address not 154th Avenue?
Yes, it is. Yes, it
Madeira
is.
Beach, 33708?
Correct.
Okay, I just wanted, thank you.
But that was, I don't know if this is a statement for later or not, that was not supposed to go to me. The rules are that it goes to the HOA, and I have a copy here that there is a manager, okay? Lisa Surzik, I think her name is, and she's registered with the city as the official person to be contacting regarding anything to do with this property. She was not contacted. I have the letter from her, and I have a letter from the president as well. I don't know if that's relevant at this point.
Yeah, I'll take a look at it in just a few minutes, sir. And again, I'm going to give you the full opportunity to share with me anything you want to share. Sir, it sounds to me like you're coming into compliance or almost into compliance, but is there any other question you have for Ms. Roby about what she testified to?
No, no.
All right.
Just the fact that that wasn't carried out what was stated on these papers.
All right, and I'm going to let you tell me all about that in
Okay.
just a moment.
Sure.
Mr. Trask, is there anyone else you'd like to call on this one?
No, sir.
All right. Sir, this is your opportunity to share with me
Okay.
anything you want. Just so we're all on the same page here, it sounds to me like you have taken down the fence. And and the question, I guess, is, finishing taking down the fence, are you going to turn it into a 3-foot fence or what you're going to do there? I mean, I think that's because that's what I'd like to hear. I don't know, Mr. Trask may want to hear some other things, but it sounds to me like, we just want to know your plan, because the corrective action I'm hearing from the city is finish tearing down the fence or apply for a permit if you want some other version of the fence.
And-
With all that, you tell me whatever it is you want to tell me.
Gotcha. I'll get to that point. I don't know if you need to answer this. This is her official letter.
Yeah, you can show it to Mr.
stating-
Trask, and then he'll let me know whether he has any objections. And sir, just so it's clear on the record, what is your official title or capacity with this entity, the Ajan Shores or Aljan Shores condo?
Aljan Shores. I'm a resident.
Okay.
I purchased in April of 2021.
Do you serve on the board or anything
Yes.
like that? Okay.
Yes. Here's another, if you want, sir. Another letter stating that this is from the president, that did not get any type of notification.
Do you have any other papers? You want to just hand it to me all at one time, so you don't have to keep walking back and forth?
Okay. I don't mind, it's a little exercise. This is a drawing from the city website that I met with Robin, the city manager, and he tried to find that, and he told me it did not exist. I bookmarked it. I do have the web address for that particular property drawing, and that shows the drawing
If you can go back over there, so we can get you on the microphone.
that my property verbatim. It shows that the front of the street, and that is considered my side yard in that drawing that came from the city website. I'm also zoned as a commercial property, which I was told I was not.
All right, anything else you'd like to share with me?
Yes, sir. I've got letters of support and a letter here from the gentleman who lives next to me that I share the fence with. He bought the property in 1991 and him and his son signed this stating that that fence had been there since 1991 when they made the purchase. Letters.
I can read it. Okay, thank you.
This fence was, as far as I know, it was a replacement fence. As I said, I purchased the property in 2021. I do have some pictures that there was a previous fence there that the previous owner had torn down. And I believe you have that, I think I saw them up there.
All right, I'm gonna let Mr. Trask look at these documents. While he's looking at that, I'll go ahead and accept into evidence as exhibit number 3, the letter dated October 18th, 2022, from Lisa Sursek, the property manager. And I'll also accept into evidence as exhibit number 4, the letter from David Knight with what appears to be some sort of location of height and fences. Mr. Trask, do you have any objection to these documents?
No objection.
All right, give me 1 second to look at this, sir. All right, sir, I'm going to go ahead and accept into evidence as exhibit number 5, the letters of support from your various neighbors. All right, what else would you like to share with me?
Let's see. That I purchased the property as is. Apparently, this is the old fence, which I believe, there it is, right there. The old fence, which I guess was torn down. That fence had been in existence there for, as it states, over 30 years. The new fence, again, I purchased the property after the fence was already there. And I don't know what the other owner did. It is a danger as well, because I live right across the street from a putt-putt place. And we have found, and I believe the president even wrote in his letter that, that we do find balls on our property. And I found, and I brought them and showed them to Robin. I had a bag full of them, a good half dozen that I brought in that we found in our backyard. Okay, not having a fence here and having a couple of drunk college kids seeing how far they can whack the ball is not an ideal thing for myself or my guests. Also, I don't know if this is the right venue, but I was going to request that because I have all of these letters of recommendation and support to be able to have the fence remain. I mean, I can't believe that somebody's going to tell me that this would be preferable, especially when you got people coming in from all over the country to have that versus that. And it complies with all of the other properties. All 3 were granted a permit to put up the fence, and it's the exact same fence that they put up as this. So it would not only improve the aesthetics, but it conforms to the rest of the property. Let's see. There was a court date for me to show up on June 27th. I believe it was June 27th. I wasn't on a docket, nobody was here. I'm almost positive it was June 22nd, yeah. And the day that this is, no, Monday, pardon me, Monday, June 27th. I think that's what I said, 22nd. On the 17th of June, this notice was attached to the fence, actually to a stake. in the front yard with no verified mail and no first-class mail received by anyone, that would effectively give me 5 days, which I'm sure you would agree would be almost impossible to send a subpoena to subpoena people to show up here. I mean, the 17th was, when it was delivered, was a Friday, and it was a week from that coming Monday. So you take out the weekends, which I don't think they serve subpoenas on the weekends anyway, you've given me 5 business days to subpoena somebody. And that doesn't seem appropriate for the city to jam me up like that. And they did it to me twice. If you look at one of these other notices, I had 5 days again to appear before the magistrate.
All right, anything else you'd like to share with me?
I showed up on the September for the magistrate hearing. I think the date was the 27th or 24th.
Okay, so I think I understand your argument, sir, and I'm going to let Mr. Trask ask any questions, but you have issues with the service, you have issues with the time for compliance, or excuse me, notice, and you want to say that the fence was there before, and that the fence is not located in your front yard, it's located in your side yard. Have I
That's
summarized that accurately?
according to that drawing, yes, sir.
All right. Mr. Trask, go ahead, and you can ask
Few questions.
witness any questions.
Were you the person that installed the fence?
No, sir.
Okay. Do you know who installed the fence?
Pardon?
Who installed the fence?
I don't know. The owner showed me this. I saw pictures from the previous owner, and I said, that's not gonna work. I'll buy the property, but that's gotta be fixed.
Okay, so before you bought the property, the prior owner put the fence up?
As far as I know.
Okay.
I would imagine.
Was there a permit issued for that fence?
I have no idea.
Okay. Were you the one that took down the fence panels?
No. Oh, yes, I did.
Okay.
You mean just recently?
Yes.
Yeah.
Okay.
Last weekend.
All right. And is there a reason why you didn't take out the posts?
Yes, because if you look, I believe she supplied a picture from this morning, you'll see that I was gonna string lights to try and keep people from stealing out of my backyard. I'm right across the street from the Putt Putt place. I mean, there's hundreds and hundreds of people that go there every weekend. And now I've got an open backyard that anybody can help themselves to. I mean, this is not right. I mean, I've got a high traffic, I'm located in a commercial zone, a C3 commercial zone, as evidenced by, again, the city's website with that photograph.
Do
that
you reside at the property?
Pardon?
Do you reside at the property?
Yes,
Okay. You reside there full-time?
yes.
Okay. All right. Do you know whether or not the condo association is aware of the fact that the hearing is going on today?
Yes.
They are aware, aren't they?
Yeah, and that's one of the reasons about the subpoena, because I wanted to subpoena the HOA manager,
Okay.
and she's out of town or something. And it was really a dereliction of duty, as
So
far as I see, that she's not here.
Did you provide them with the notice of the hearing today, or did they had already received it?
She provided me with the notice of the hearing
Okay.
because it was staked in the front yard.
Okay.
The last 3 notices, the first notice was taped to the fence itself, okay? I took that one down. Then the subsequent notices were posted on a stick in the front yard.
Okay.
There was no mail that was received because I talked to the HOA person and the president of the HOA.
Are you going to apply for a building permit to put a fence back up?
Well, I don't know if that's another hearing or whatnot. I think that it would be fair to allow me to leave the fence as it was.
My question to you is, are you going to apply for a building permit to put the fence up?
I guess it depends on what you guys say. If I would, I don't have a problem in doing that.
Okay, that's what I wanted
But
to
if
find
I can keep the same original fence without making any alterations, a 3-foot fence is not gonna make a difference. Somebody's still just gonna step over a 3-foot fence and take whatever they want out of my backyard.
All right, well-
But before all of that argument, The drawing shows my property.
You answered my question, thank you. I don't have any other questions for Mr. Cusimano. Sorry if I mispronounced your name.
Yeah, sir, I think what Mr. Trask was asking and what I'm trying to figure out is if you look on page number 137 and 138 of the agenda package, if you guys wouldn't mind bringing that up. Just give me 1 second, sir. I just want to make sure I understand when you talk about the fence that was there.
Yeah.
I'm looking at what appears to be a relatively new wooden shadow box type fence that's up there, which looks to replace some other type of fence. That one right there is fine.
Right.
I think what Mr. Trask was asking, what I want to know is, are you the person who built that particular fence?
Was I the person?
Yes.
No. I
Okay, so that
purchased
was-
the house like that.
Okay, and are you aware of when did you purchase the home? Do you recall?
April
condo?
2021.
When you purchased it, do you know whether or not there was a building permit issued for that
I have no-
particular wood fence?
I have no clue.
Okay. Okay.
Just like there was a new water heater installed too. I don't know if they, but, you know, I didn't do it. So, no, I really don't know if there was a permit pulled or not for it.
All right. Is there anything else you'd like to present to me today, sir?
Yeah, I'd like to be able to keep that fence that I took down.
Okay, I understand. All right, this is the portion of the hearing where we accept public comment from anyone who would like to comment. Any members of the public that would like to come up? All right, seeing none. Mr. Trask, anything else?
I just want to make sure that I tendered into evidence the agenda package, pages 131 through 158.
Yes, I did accept that into evidence.
I didn't mark it, thank you.
Mr. Trask, can you address this argument that the respondent is making, that it would be as to the violation as to whether or not this fence is in the front yard or a side yard or rear yard or something else like that? Can you address, I guess that would be section 110-441.
It's the second photograph, the second drawing, if you gotta go up. Yes, that one.
So the answer to the question is no, I can't address that. I don't know specifically. But if he was going to apply for a building permit for the fence, he could bring that to the attention of the permit technician to determine whether or not that particular section applied, and then ultimately provide a survey as to where the fence is going to be. But in either event, he needs to get a building permit, so.
Okay. What is the corrective action the city is seeking, and what is the city seeking relief-wise?
The city wants him to remove the fence posts, and then once he removes the fence posts, he will be in compliance. As for the order, if you do find a violation of the cited code section, give the condo association 7 days to bring the property into compliance by removing those fence posts, or subject the property owner to a fine of $50 a day. It is not a life safety issue. That's why I'm suggesting the lower $50 per day.
All right.
If,
And, hold on, sir, hold on. Mr. Trask, I'd like to ask someone from the city, if he were to come in and ask for a permit and have the discussion whether this is a front yard, a side yard, a rear yard, what kind of, I get it, we're going into the holidays and I don't know what's going on. What would be a reasonable time to give him to come in and ask for a building permit or a building permit review to address his issues as to whether this is a front yard or side yard?
So I'd rely upon city staff to maybe pipe in here, either Jenny or Holden or Frank.
Yes. Based on the photos in the packet, it appears that the fence is in the front yard. So the front yard is anything from the front face of the building towards the street.
If you look at the second drawing, which I don't know why you could keep pulling it
Well,
down.
hold on. What I just really want to know is if the respondent here were to come in and want to have this discussion and apply for a building permit, what kind of time would you guys need on the city to review that permit, have whatever discussions you would need to have, whatever debate you want to have about where the fence is located, and then come to a conclusion one way or the other on the building permit?
I would say, given like meetings and discussions, I would give about a month.
Okay, 30 days, all right.
Yes.
Okay. Mr. Trask, that's all I have. Is there anything else you'd like to point out here?
No, sir.
All right. Sir, here's what I'm going to do. I'm not going to find you in violation of the first one, which is section 110-447, because you've removed it at this point. So there's no existing 6-foot fence, whether it's in the front yard or the side yard. And the fence posts, however, still will need to either be removed or you'll need to get a permit. The city's asking for 7 days. The reason I wanted to ask the question is I'm going to give you 30 days to go talk to the city, try to see if you can't work out this issue with the city as to whether or not you can build a fence there, and if you can build a fence, what you can build there. All right, so you're going to have 30 days to either either remove the fence posts or get a building permit to build what you want to build there that's acceptable to the city.
Okay.
All right? And the only violation I'm going to find is 86.52. Because you have taken steps for compliance, I'm going to do a $25 a day fine thereafter. However, if you are getting close to an agreement on the city and you're going to need more time to build whatever it is you want to build there, then you can come back to see me. You can work with the city for it to be put on notice. And again, I'll consider whether or not to push back the compliance date or something like that. So I'm going to find the property in violation of 86-52. The corrective action is to remove the fence posts within 30 days, or there'll be a $25 a day fine. No violation of 110.447. And again, I encourage you to come. You have 30 days now to come and try to work this out with the city.
Can I ask, who is it that I would be speaking about regarding that drawing?
Anybody want to raise their hands over there, or anybody can direct the out?
It'd be the
respondent?
planning department, so you can contact me. My name's Jenny
Do
Rowan.
you have a card?
Not here with me, but I can write down my information and give that to you.
All right, thank you, sir. That is all for public hearing on case 2022.3431. All right, we have one other case on the agenda today, which is case number 2022.3387 for the property located at 13227 3rd Street East. I believe, Mr. Trask, this is one that I asked to be put on the agenda because I received some ex parte communications from the respondent. Is that correct?
That's correct. There was a request for a postponement or continuance. I think that the appropriate request would have been a motion or a request to change the compliance date. The compliance date in the order is September 30th. The city has no objection to extending that compliance date until December 30th. That's 90 days for them to do what they want to do. But otherwise, the fine would kick in at that point if it's not brought into compliance by that date. And you remember that he had already been given 60 days, so this will be an additional 90 the city has no objection to that.
Understood. Hi, I'm Bart Valdez. I'm Special Magistrate. Can you make your appearance for me, please?
Yes, Allison Doucette on behalf of the owner, Bernard Scott LLC, and Mr. Lavender is here as well as representative for the owner. I did have correspondence and discussions with Mr. Trask regarding the request for extension. There are a couple of extenuating circumstances, including Mr. Lavender's illness with COVID during the intervening time, as well as, he has been in discussions, and I don't want to get into too much of it because Mr. Trask and I agreed to limit this just to the continuance request, but I did want you to know as special magistrate, Mr. Lavender is working on compliance. He has made efforts to try to figure out if there's a middle ground that the city might approve for use of that building, which has been a converted garage space since he purchased it and for many years before. So we have some additional information that I think the city might be willing to consider at this point. So we plan on, and we have reached out to the building department in order to discuss any other potential uses of the property, but the owner is prepared to comply. We just want some time to do so in order to make the best use of the property if that's possible.
Understood. Thank you, Ms. Doucette. Do you have any objection to the compromise that Mr. Trask has proposed?
With 90 days?
Yes.
No, that
All
is
right.
what we requested.
All right. And Mr. Lavender, please understand, the reason that I set this for hearing is I can't communicate with you outside of a public hearing. In fact, under Section 2.384 A and B, all my communications with anyone have to be in a publicly noticed hearing. So I'm not trying to ignore your request or anything like that. It's just simply that these are public proceedings, and so we can't do anything that is outside of a public hearing. What I would ask, Mr. Trask, if you can work with Ms. Doucette, come up with a proposed order that is acceptable to both of you, and if you guys can just email it to me with a cover email saying that it's agreed upon, I'll go ahead and sign it and get it out. And Ms. Doucette, I think we're already communicating with your firm, but I assume you just want me to send it to you by email at your address, the Allison D address?
Yes.
Okay.
Yes, Allison D at BLHT Law, and that would be wonderful, and then I'll make sure Mr. Lavender gets it, and we'll follow up with the appropriate people on the building and planning side.
All right, so I'm going to go ahead and approve the joint stipulation as stated on the record today. I'll wait and enter that written order as soon as you guys submit it to me. And is there anything else I need to consider on this particular matter today?
No.
All right, are there any other matters on the agenda today?
No.
All right, that concludes today's special magistrate hearings. Thank you very much.
Thank you.